Welcome to the AdaKay Show. I'm your host, AdaKay, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member.
Good morning. Good morning. Thank you for joining us this morning. We have a busy court day between the Massachusetts versus Judy Church. We're going to start with them this morning. Then we will move back into the Georgia versus Suzanne Miracle for the recap of day 2. And then if you join us later on this afternoon, evening time frame, we do have the Hawaii versus Dr. Koenig, and we will be covering all of those trials today. I hope that you guys have your coffee, your tea, whatever you prefer to drink in the mornings, and you have some energy for the long trial coverage day. Let's go ahead and get into the Judy Church trial. I'm going to get that started for you guys right now.
And good morning to all. Good morning, Mark. Good morning, Mr. Scully. Mr. Norkunis, what is the decision of Ms. Church whether or not to testify?
She has chosen not to testify, Your Honor.
Okay. Ms. Church, I'm going to have a brief conversation with you about that decision. If you would stand up just while we chat with each other. No need. Ms. Church, Mr. Norkunis has told me it's your decision not to testify at this trial. You've heard me state over and over again throughout the course of this trial to this jury that a decision of a defendant whether or not to testify is theirs to make. They have an absolute right not to. And if you do not testify, I am prepared to tell this jury in my final instructions that they may not consider that in any way in assessing whether the Commonwealth has proved the charge made against you. And I'll go so far as to tell the jury that they may not even discuss the fact that you've chosen not to testify in their deliberations. What I want you to understand, however, is that you have an absolute right to testify if you wish to do so. Do you understand that?
Yes.
It's important that you have consulted with your attorneys, Mr. Norkunis and Mr. Scully, about this decision, and I have no doubt that you have. I've provided opportunity for you to do that. And it's important that you give due consideration to their advice and counsel because they're very able and experienced attorneys. But in the end, it's your decision whether or not to testify. Do you understand that?
I do.
So regardless of whatever advice you may be receiving from your attorneys, if you wish to testify, you have the right to do so. Do you understand that?
Yes.
Is it your decision, Ms. Church, not to testify?
Yes, it is.
Thank you. You may be seated. Just a couple of other housekeeping matters, or really matters that relate to the instructions, and we're still waiting for 2 jurors, by the way. First, with respect to my practice, which you may or may not have noticed in reading the instructions of letting the jury pick their own foreperson, does anyone have an objection to that practice? Mr. Camilio?
No, Judge.
All right, very good. I think I sent the added instruction, the Commonwealth requested instruction on prior inconsistent statements. I was operating and addressing that particular request under the federal rules of evidence and not ours, uncorrected by anyone else, I might add, that these statements come in substantively. They do not. So actually the limiting instruction is appropriate in any event. As I said in my email to Ms. Draper that I think she probably included in her email to you, I just worked right off. There's a very good district court model instruction, which is what I used. Any issues with that instruction, Mr. Camilio?
No, just thank you for saving.
No issues, Your Honor.
All right. 2 other things about the instructions that I've tweaked just a little bit that I want to bring to your attention, and I haven't yet printed out copies because I'm going to go back and send them to our judicial secretary, and each counsel will have their own copy. But first, in terms of selecting a replacement deliberating juror, should we come to that, what I've always said in my instructions is that we would just select the first chosen alternate to go in first if we lost the deliberating juror, then the second alternate. I've tweaked that a little bit, really to comport with Ms. Draper's fairly standard practice, and I think it's probably a fairly standard practice elsewhere, which is that if we were to lose a deliberating juror, we just take the 4 selected alternates, put their numbers in a drum, and randomly select a replacement, and do that anytime we needed to select a replacement. Any issues with that, Mr. Camilio? Mr. Scully?
No issues.
All right. Finally, I did a little tweak to the section that discussed the verdict form because I realized I referenced 3 options: not guilty, guilty first-degree murder, guilty of second-degree murder, which did not reflect the fact that there's 2 theories of murder. So there's really the options are really 4. So I just tweaked it to reflect that the verdict form has not guilty, guilty first-degree murder, deliberate premeditation, guilty first-degree murder by extreme atrocity or cruelty, or guilty of second-degree murder. So those are the only changes I've made. Any issue with that, Mr. Camilio? Mr. Scully?
No, I don't think so, Judge.
That's all I had. 2 defense witnesses this morning?
Correct. 2 defense witnesses, both present.
Both present. Excellent. We're all set then. All right. So you can line them up and bring them in.
I just have one thing before we bring in the jurors.
Sure.
I did get an email from Mr. Scully last night about the medical records that he plans to read to the jury this morning. And obviously, I don't have a problem with reading some medical records to the jury, but this, by my count, is 17 pages of medical records, which I think might be.
That is too much.
I think it comes down to about 25 words.
In total?
I think it's something like that. So the pages are, there's a date of a page. So I gave him the page rate for the medical records. So like page 43 to 46, which is part of Exhibit 8. I'll read the date and then turn to page 46 and read the 5 words on that page that I highlighted. And then I'll go to the next one. So I think it came out to like 25 or 30 words.
So you're talking about just a minute or 2 in front of the jury?
I think a minute or 2. My plan was to just, because I don't want to drop the paper.
That's acceptable. I think Mr. Camilio's concern was you were going to be up there reading 17 pages. That's fine. That's fine. Absolutely fine. One last thing is it's my expectation that we will hear the testimony of the 2 defense witnesses. The defense will rest. We'll excuse the jury. I'll hear the defense motion, and then we'll give counsel a break before we proceed to part 1 of instructions, closings, and then the final instructions.
Thank you, Ron.
All right. So we're set whenever the jury comes in. Do you want to?
I'm gonna, I have
Yes, copies for them.
show.
Okay.
This had the incorrect document.
Oh, okay. Yes, we are. Thanks, Matt.
All set.
Good to go, man. Good to go. Come right in. Oh, yes.
Thank you.
All right, for the jurors. Be seated.
Good morning, girls. Since we saw each other yesterday afternoon, Has any member of the jury discussed the substance of this case with anyone, including among yourselves? No. We'll ask each other, has any member of the jury seen, read, heard, or overheard anything from any outside source about any aspect of this? No. Excellent. We're continuing with the presentation of the defense case. The defense counsel may call their next witness.
Thank you, Your Honor. Defense calls Dr. Edmund Crouch.
May we pause for just a moment? I want everybody to stay in place. I'm going to absent myself for about 30 seconds. I forgot to do one thing before I brought you in. We have finalized the jury instructions. I need to send them to our judicial secretary to start copying them, and I want that to occur while the witness's testimony is going on. So people stay in place. I will leave the bench. No stand up, sit down. I'll just come and go in a moment. I'll be right back.
You want him to go to the witness stand?
No, I'll wait till the judge.
Do me a favor, just stand. I'm going to stand right there. I'm going to stand over here.
What did you do while I was gone?
Sir, would you raise your right hand, please? Do you solemnly swear the testimony you're about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth to help you God? Thank you. You may be seated.
Thank you. Good morning, sir.
Good morning.
Dr. Crouch, there's a microphone in front of you that not only will amplify your voice so the jury and others hear it clearly, but it also is recorded. So if you can stay as close to that microphone as comfortable and possible.
Thank you.
That
Is
will be
this
good.
okay?
I think so. So in a loud, clear voice, could you please introduce yourself for the record, stating your first name and spelling your last name?
My name is Edmund Crouch, Crouch.
And I referred to you already as Dr. Crouch. What is the basis of that title?
I have a PhD.
Okay. So Dr. Crouch, with respect to that, could you describe for the jury your educational background?
I started in a high school in England, what would be called a high school here, public school. It was called a public school in England, which was actually semi-private. Moved from there to Churchill College, Cambridge, where I studied natural sciences and obtained a BA in natural sciences, which automatically converted to an MA after 3 years of good behavior. And subsequently did a PhD in theoretical physics.
Okay, and where did you obtain a PhD in theoretical
This was
physics?
all at Churchill College, Cambridge,
Okay.
England.
And how long have you been a PhD? Or what year did you obtain it, if you recall?
About 1972.
Okay. And that was in England, obviously,
That
right?
was England, yes.
And you still have your English accent.
I'm told that, yes.
You live in America
Yes,
and in the greater Boston area
yes.
for how many years?
It's now, I think, 46, 49 years, something like that. I came over in 1977.
And could you briefly describe for the jury any professional associations that you belong to? And if there's a long, long list, you don't have to name them all, but to give them a sense of those.
Well, I'm a member of the American Association of the AAAS. I forget the full
Okay.
nomenclature. The American Mathematical Society, the Mathematical Association of America, the Society for Risk Analysis, maybe a couple of others. Oh, the American Chemical Society.
And over time, have you published papers and articles in the field that you work in?
Various papers in various fields as I move through various fields of work.
Now, employment-wise, what do you do now?
Now I'm part of a two-person small company, both of us semi-retired. We consider ourselves consultants. We work for clients when on pretty well whatever they want to do with chemistry, risk assessment, toxicology. My colleague is a chemist and toxicologist. I consider myself a risk assessor, but that covers a wide range of fields, but primarily chemical risk assessments of chemicals.
Okay. And prior to that, from 1992 to 1994 or thereabouts, were you a lecturer at Harvard University?
For a short time period, yes.
And after, during that period and until about 2012, did you work as a senior scientist at Cambridge Environmental Incorporated in Cambridge, Massachusetts?
Yes.
And after that, were you a principal at C.D. Smith in Cambridge?
Yes, that was my title, I believe.
And have you also associated with Harvard University in the Department of Physics for many years?
Yes, that came over originally in 1977 to work as a postdoc in the Jefferson lab.
Okay. And so did there come a time when you were approached by the defense team in this case to look at the amount of ethylene glycol that was present in certain locations?
Yes, I was.
Okay. And could you describe basically, you know the name Leroy Fowler, right?
Yes.
Did you undertake something to look at how much ethylene glycol was in his system at the time that he died?
Not at the time he died, at the time he first presented at AdaKay Hospital.
And so part of what you did was look at how much ethylene glycol was in his system when he first presented at AdaKay, right?
That is correct, yes.
Did you come to a conclusion about that?
I did, yes.
What was that?
My conclusion was that he held, at the time of presentation, he had about 28.5 grams of ethylene glycol in his system.
Okay. And in order to get to that conclusion, how did you get there, basically, if you could explain to the jury?
Yes, I started with the measurement of ethylene glycol in his blood performed at NMS labs on behalf of the state police labs. They contracted it out to NMS. That was a measure of 2 milligrams per deciliter, which is the same as 520 milligrams per liter. Now, ethylene glycol, when it gets into the body, when it's ingested, is absorbed fairly rapidly and spreads throughout the body, carried around the body by the blood. And in the body, in the blood and throughout the body, it's dissolved in the water. of the body. It doesn't dissolve pretty well at all in fat and protein and muscle and bone. It's just in the water component of those parts of your body. Now, we can estimate accurately the total amount of water in the body. This is a subject which has been extensively studied in the literature because it's useful in pharmacokinetic calculations. And it can be estimated accurately from one's height, weight, and age. And I estimated that using the best available methodology in the literature. And that came out to 46.5 grams, 45.6 liters of water, which is the same as 46.5 kilograms, which is about 51% of Mr. Fowler's body weight at the time of presentation to Anna Jacks. So with that information and the concentration in blood, well, that's the concentration in blood. The concentration in the water is a little bit higher because blood is only about 85% by volume water. So the concentration in the water, in the blood, and hence in the total water in the body is higher by a factor of 1 over 0.85. It's 85%. Sorry, not 80%. 1 over 0.85 times the concentration in blood, which gives you 612 milligrams per liter. So now it's 612 milligrams per liter and 46.5 liters. Multiply the two together and you get 24,800, I think it was, milligrams of ethylene glycol in the whole of the body water. And that means in the total body, which is 28.5 grams total.
Okay. And so, so you were able to come to that conclusion, and you were largely on the medical records from Anna Jacks Hospital and the laboratory records that tested his blood at NMS laboratory, right?
Yes, Anna Jacks gives me the body weight when he got there, have the date of birth from various sources to get his age, and the weight, and his height was measured at autopsy as 5'10". So I got his height, weight, and age.
By reviewing the autopsy report and records.
That's correct,
Okay.
yes.
Now, so you've got that calculation for the amount of ethylene glycol in his blood at presentment at Anna Jacks.
Well, in his whole body.
In his whole body.
Yes.
And did you then also seek to determine how much ethylene glycol was in what's been referred to as the sample from the Powerade that NMS tested in this case?
Yes, again, the state police lab contracted out to NMS and they measured the residue from the Powerade bottle. So that if the bottle had been full with liquid corresponding to that residue, so it was the same stuff as that residue, the residue contained 2,400 milligrams per deciliter, which is 24,000 milligrams per liter, which is 24 grams per liter. And the bottle was a 20-ounce bottle, 20 fluid ounce bottle, which is exactly 0.6 of a liter. That's a USDA requirement for labeling, that you have 1 fluid ounce is exactly 30 milliliters. So multiplying those two together, the volume of 0.6 liters and the 24 grams per liter gives us 14.4, I think it was, grams of ethylene glycol in a full Powerade bottle containing a liquid similar to the residue.
Okay. So what was left in the Powerade bottle was sort of a residue amount, small amount, right?
Yes,
But it had a percentage of it that was ethylene glycol, right?
yes.
And you remember what that percentage by weight was?
Well, it was about 2.4%. That's
About
24 grams per liter.
About
because of-
2.4%.
Yeah,
And then what you extrapolated is if the bottle had been full to its 20 ounces, then it would have contained, based on the 2.4%, 14.4 grams of ethylene glycol, right?
if it was the same as the residue, yes.
If it was the same.
If the contents of the bottle were the same as the residue, yes.
So in order to get that amount of ethylene glycol that was in Leroy Fowler's blood system, would drinking one full bottle of the Powerade have been sufficient?
No.
Okay.
It would require about twice that, two bottles full.
So would it be fair to say that it would require at least 2 bottles?
Yes.
Okay. All right. Thank you very much. No further questions, Your Honor.
Mr. Camellia.
Thank you, Judge. Good morning, sir.
Good morning.
Before I get to your math, we'll call it, I just wanted to ask you a few questions about ethylene glycol itself, okay?
Yeah.
All right. So ethylene glycol, it's a chemical, various consumer products, correct?
As far as I know, yes.
Okay. Well, you actually wrote that report.
Yeah.
So you do know that.
Yes.
And the main places that it's found for consumer products is in AntiFreeze, yes?
I don't know the relative amounts of ethylene glycol in various different consumer products, but antifreeze is certainly a major component.
Okay. Ethylene glycol is a sweet tasting liquid, yes?
Yes.
Okay. And because it is sweet tasting, it can be dangerous, correct?
Apparently, yes.
And because it is sweet tasting and oftentimes colorful, it can be accidentally consumed by some people, right?
Yes, it is indeed accidentally consumed by quite a few people, unfortunately.
And in order to try to prevent people from drinking it when they don't know that it's in whatever they're drinking, this bittering agents are added to it, correct?
Yes.
Okay. And unfortunately, bittering agents have been shown to not prevent the ingestion of ethylene glycol, correct?
That's correct, yes.
Once we started adding bittering agents to antifreeze, the number of ethylene glycol poisonings in the United States remained basically the same, correct?
That's true, yes.
Okay. Now, in order to do your calculations, which I will confess, law school did not prepare me for, you had to make some assumptions, correct?
Yes.
All right. You had to make an assumption about the total water in Mr. Fowler's body.
I had to calculate that.
Okay. Well, but you don't know, you calculated based on averages, correct? Based on averages for an average person weighing 5'10", weighing Mr. Fowler's weight and Mr. Fowler's age.
That's correct,
Okay.
yes.
So everybody's different, and so
Yes.
those things vary from person to person.
Yes.
Okay. And if an individual is dehydrated, the amount of water in his body will be lower.
Yes.
You also had to make an assumption about how long it takes for ethylene glycol to reach equilibrium in the total body water, correct?
That's correct, yes.
So depending on the number that you choose for that assumption, that would change the amount of ethylene glycol that was present in the body water, correct?
Yes.
Okay. So when a drink, and I'll just use my bottled water here as a substitute. When somebody drinks a liquid containing ethylene glycol, or really containing any liquid, first place it goes is into the stomach, correct?
Correct.
From the stomach, it then goes into the bloodstream.
Well, usually from the small intestine or the intestines rather than the stomach, primarily.
and then it hits the bloodstream,
Yes.
and then it starts to make its way through the water in the body.
Yes.
Okay. Now, at some point, a substance like ethylene glycol that hits the bloodstream is going to hit what's called Cmax, correct?
Well, define what you mean by Cmax.
Cmax is the highest concentration of that particular substance in the blood. Yes?
If you define it that way, that's the way it is. Yes.
Not familiar with that term?
I've seen it in multiple situations, multiple contexts.
All right.
I mean,
And so Cmax at some point is going to be higher than the concentration of whatever that particular substance is in the body of the total body water, correct?
no.
No.
I mean, if it's the concentration in the blood, it's the concentration in the blood.
Well, it's the concentration in the blood, but the concentration in the blood is
Oh,
not the same as the concentration in the water
For some period
of time.
of time, the concentration in the blood will be higher than in the total body water on average. Yes.
Exactly. So if the blood was measured at a time when the concentration in the blood was higher than the concentration in the water, that would affect your calculations.
Yes.
And your calculations would essentially not be correct.
They would not be correct if that was true. Yes.
So the takeaway from your testimony, as I understand it, is that it's possible that the blood was measured before all of the ethylene glycol hit the water in the body.
In this case, no.
No, not. Okay. Why not?
Well, Mr. Fowler was observed, I believe, at least 7:30 and possibly earlier, already under the influence of some substance.
Fair.
So
and it can take up to 4 hours in a healthy person for that ethylene glycol to reach equilibrium in the total body, total water body. Correct?
No, it would be a bit shorter than that.
So
2
studies
hours.
have shown between 1 and 4 hours is how long it takes for ethylene glycol to reach equilibrium in the water.
Now, I would
Yes?
say at most 2 hours.
And as you noted in your report, if someone has particular health problems, that can cause it to be even slower.
No, that slower thing is the metabolism, which is a different thing entirely.
So you agreed with me that if the ethylene glycol in the blood was higher than in the body the water, total body water, your calculations would be incorrect.
If that was true, but in this case, it was not.
Okay, well, thank you for that. So your conclusions can either be broken down into two things. I know you're not going to agree with me that your calculations are wrong, but that's one possibility. The other possibility that you're raising is that Mr. Fowler was actually being poisoned in multiple doses.
Not necessarily.
Not necessarily. Well, he had 52 milligrams per deciliter of ethylene glycol in his blood. Yes?
Yes.
Okay. And you say there wasn't enough in the Powerade bottle to have gotten his blood to 52 milligrams per deciliter, correct?
Yes.
So the rest of the ethylene glycol that was in his blood had to come from somewhere.
It came from somewhere else than from one drink of Powerade of that bottle, assuming that the residue is the same.
Assuming that the residue is
Yeah.
the same. And that's another assumption you had to make.
That's correct. Yes.
Thank you, Judge. I don't have anything further.
Mr. Scully.
Basically, based on your calculations, assuming the residue was the same,
Mm-hmm.
you would have had to have drank at least 2 bottles of that Powerade.
Well, there had to be some other source, or not some other source entirely. Yes.
Okay, no further questions.
Mr. Committee, follow up on
No,
that.
thank you, Judge.
Thank you very much, Dr. Crouch.
Thank
You may
you.
step down.
Thank you.
The next defense witness.
Thank you, Your Honor. Defense calls Dr. Stephen Lakin.
ask you to stand behind the line and take the oath.
Sir, do you solemnly swear the testimony you are about to give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Just have comfortable in your chair.
Morning.
Good morning.
As you know, the microphone there projects your voice for the jury to hear it, and it also triggers the recording, which is taking place, so transcripts can be made later, if necessary. So just please use that microphone to the best of your ability.
I will.
Okay, thank you. And in a loud, clear voice, could you introduce yourself to the jury, say your name and spell your last name for the record?
Good morning. My name is Stephen Laken, Steven, Laken, Laken, and I have a PhD in cell and molecular medicine from Johns Hopkins.
Okay, and so that's why I refer to you as Dr. Laken, correct?
Yes.
Dr. Laken, in addition to that PhD, could you summarize basically for the jury your educational background?
Yes, I earned my Bachelor's of Science degree from the University of Minnesota in genetics and cell biology. I worked as a technician for a year. I was accepted into graduate school at Johns Hopkins Medical School. I worked on my PhD for 5 years. I earned a great degree in cell and molecular medicine. My concentration was in genetics and cell biology. I then joined a company called Exact Sciences, which helped commercialize an FDA-cleared colorectal cancer screening test called Cologuard. And then since that time, I've been working on a number of startup companies, help consult with companies that are working on new diagnostics devices, and also do the DNA forensics work.
Okay, and so just so I'm clear, did you study at the University of Minnesota and obtain a bachelor's in genetics and cell biology?
Yes.
And did you study thereafter at Johns Hopkins School of Medicine and obtain a PhD in cellular and molecular medicine?
Yes.
Okay. And did you complete your education, graduate from Johns Hopkins in 1999?
Yes.
And been working in the private sector since then?
Yes.
And currently, what is your job?
Currently, I have a company. The company's called Cephos, spelled CEPHOS. Since between 2007 2008, I started working with attorneys consulting on DNA forensic cases. Most of my work is all of my work is working on the defense side, and I've worked on around 1,300 cases, as well as a number of wrongful conviction cases.
Okay. And is it fair to say that in that area of work that you do now, frequently defense lawyers such as us give you DNA data and reports and conclusions that were generated in cases by the Massachusetts State Police Crime Lab?
It can be the Massachusetts State Police Crime Lab. It can also be private labs or other states.
Okay, and sometimes the crime lab contracts out with other laboratories to do certain types of DNA work?
Yes, that's correct.
And is it fair to say that you get all the data and do a top to bottom review of it to see if you spot issues?
Basically, what I do is ask for what's called the DNA case file, which is generally the lab's notes and written contemporaneous records along with the testing that gets done. I ask for those along with what's called the raw electronic data, basically the data that goes into producing a DNA profile. There may be criminalistics reports. In the cases of criminalistics reports, those are people that are basically analyzing the evidence at the crime lab, maybe taking pictures or doing certain serological testing or testing for biologic fluids. I may review some police notes and police records. And then basically I come to my own opinion and then communicate those to the attorney.
Okay, and did you undertake to do that in this case with respect to the DNA evidence that was provided to you by us relative to this case?
Yes.
And do you recall looking at DNA evidence relative to item 2-1.2.1, which was described as the handle and an exterior cap of a bottle of de-icer.
Yes.
And is it fair to say that several profiles, at least 3 profiles, were generated as a result of DNA testing done on that item?
Yes.
Okay. And you reviewed those profiles and that data to see if you identified any errors, correct?
Correct.
And did not?
Correct.
Okay. And there was also DNA data and materials presented to you in connection with item 2-2.2.1, which was described as the sample of exterior Powerade bottle.
Yes.
And similarly, this sample, what was presented to you is there was a number of profiles, at least 3 profiles generated in connection with that, right?
That's correct.
And you did a review top to bottom to see if there were any issues with those profiles.
Yes.
Fair to say didn't identify any,
Correct.
not challenging those.
Correct.
And then there was the a third item that I would draw your attention to, which is 2-2.3.1, which was described as the sample of mouth of interior cap of the Powerade bottle, right?
Yes.
And again, that had at least 2 DNA profiles, right?
Yes.
And you looked at the data behind that to see if there were any issues that you disagreed with in terms of those generating those profiles, right?
Yes.
And you did not.
I did not find any issues.
Now, so the profiles are not necessarily an issue that you're here to testify about, right?
That is correct.
You looked at them, but that's not what you're here to talk about today.
Yes.
What we want to ask you here today is about, well, how does DNA get a person to an item?
There are 2 different types of DNA transfers that are generally referred to in the field. One is called primary transfer. So primary transfer is when I'm touching or handling an object. For example, if I pick up my notebook here, I handle this notebook, then I'm leaving the DNA potentially from my hands onto that notebook. That would be a primary transfer. My DNA is on that notebook. When I walked into the courtroom, I opened up the door. It's possible that in the process of opening up the door, I collected somebody else's DNA who opened up the door before me, and that DNA may be on my hand. That would be a case of secondary transfer. Their DNA went through, for example, the doorknob, and then I picked up that doorknob, or I picked up the DNA from the doorknob or the door handle, and then have transferred that, or it's on my hands. So DNA can get transferred multiple times. It can be left on objects for quite a long period of time before it degrades away and disappears.
Okay. So primarily, direct contact is one way where you touch something, right?
Correct.
And secondary transfer is another common way, right?
Is another way that I can pick up somebody else's DNA inadvertently and transfer their DNA or handle their DNA.
In primary direct contact cases, DNA exists in what form in terms of cells, saliva, other ways that it would be transferred?
We're constantly shedding our DNA. Most of the way that we shed our DNA is through a process of skin cells or the cells that are on my face. We can also transfer DNA through the process of talking. In fact, we're talking or sneezing, as the case may be. We also may transfer a lot of our DNA externally that way. So for example, in the laboratory, to take precautions to prevent me from leaving DNA on objects that are being tested, wear a face mask to basically prevent any DNA if I cough or I sneeze, or even in the process of talking, I may be leaving and spreading DNA from my mouth. I wear basically gloves, and the gloves are to prevent my DNA from my hands being transferred to any object. And the sleeves in the laboratory are a little bit different than a common lab coat that's worn. The lab coat that's worn, the sleeves have cuffs that are relatively large, and those cuffs are basically meant to go across my wrist. And then when I wear gloves, I can put those gloves and overlap those gloves on my wrist so that there's actually no gap between the gloves and my lab coat that such that that DNA may be dropping down on top of things. I also wear a hairnet, and the hairnet or a beard net are those to basically prevent DNA from my hair or the skin on my hair from shedding off and landing in tubes.
Okay. So is it fair to say that a DNA analyst or scientist, when they detect DNA present on an item, that's not the same as detecting when and where or how that DNA got on the item?
That's correct.
All right. And when and where and how is really outside the scope of the DNA expert's abilities, right?
That is correct.
You're looking at profiles. It's there, or it isn't there, or there's a percentage chance that it's there. A statistical chance.
So yes, that's absolutely true. The statistical chance is when we see a profile, what's the chance of finding a profile that's similar to that in the population, not the chance of finding a profile left on that item.
So we have, as an exhibit in this case, a Powerade bottle, which is identified as Exhibit 30 here. So if I'm following what you said correctly, one way that DNA can get onto this bottle is through sort of a direct handle touch primary transfer. Is that right?
Yes.
And a second way could be if the person who's doing that direct touch of the bottle also has DNA of someone else that they have picked up somewhere along the way, right?
Yes.
Either directly from having contact with that person, right?
Yes.
Or sharing a bed with them,
Yes.
or touching a door handle,
Yes.
or just living in the same home.
Yes.
Okay. And is a third way that possibly this surface here that I've been using could have my DNA on it, right?
Yes.
Might or it might not, right?
That's correct.
This surface has been here a long time. It could have other DNA on it, right?
Yes.
Okay. And is it possible that if an item is placed on this surface, that there could even be a transfer that way?
It's possible. Yes.
Okay. All right. Thank you very much, Doctor. I have no further questions.
You're welcome.
Ms. Strasnick?
I may just have a moment to grab a couple exhibits.
Yes, you may.
Thank you. While he's looking for the one exhibit I can't seem to find.
Sorry about that.
Good morning, Dr. Lakin.
Good morning.
You reviewed the work that was generated by the Massachusetts State Police Crime Lab in this case, right?
Yes.
And you'd agree with me that they're an accredited lab?
Yes.
Their analysts pass proficiency and competency tests, right?
Yes.
And it's your opinion that the Massachusetts State Police Crime Lab is one of the best that you've observed?
Yes.
And you've had many opportunities to actually go to the lab and make observations of them conducting various types of DNA testing, right?
Yes.
All the things that you just described to the jury that's important to protect the integrity of testing, such as the gloves, the mask, the hairnets,
Yes.
the coats, they do all those things, right?
Yes.
And you've observed that, right?
Yes.
You'd agree with me that you're not a DNA analyst, right?
I'm not a DNA analyst.
You're not a forensic scientist, right?
I'm not a forensic scientist.
In fact, as you stated, you're a defense DNA expert, right?
I wouldn't say that I'm a defense DNA expert, but I am a DNA expert, yes.
How many times have you testified for the Commonwealth?
I have not been asked by the Commonwealth to testify, but I'd be happy to. And
How
so
many times have you testified for the defense?
Probably around 60 or 70 times.
And how many cases have you done work for the defense as a DNA consultant?
I have about 1,300 cases.
And it's fair to say that being a DNA expert for the defense has become quite lucrative to you, hasn't it?
It pays bills, yes.
In fact, in 2026, the fiscal year, you've made over $200,000 just for Massachusetts cases where you've been retained as a defense expert, correct?
My company has billed that, yes.
And between you personally, because you used to charge personally and then you changed it to CFOs, is that how you say it?
Cephos.
CFOs for the billing. And during the course of your time as a DNA expert with Massachusetts, you made approximately $2 million doing DNA cases for the defense, right?
Yes, I've been doing this since 2008, correct?
I didn't hear the witness's answer.
Yes, I've been doing this since about 2008.
2008.
2008, yeah.
So we talked a little bit about secondary transfer and direct or primary transfer, right?
Yes,
And that's what I want to talk to you about. Secondary transfer, you said DNA gets on an item indirectly through another person or object rather than direct contact, right?
yes,
So some type of casual contact from the environment in which someone or something is, right?
it could be casual, yes.
Are you familiar with how blood is taken at a hospital or at a medical provider where it's put in vials, right?
Yes, I've taken blood samples as well for DNA.
Okay, so perfect. You're familiar with that. You put the blood into a plastic or glass vial, right?
That's correct, yes.
And if I were to shake your hand and I touch the vial, you're saying it's possible that your DNA might be on the outside of that vial, right?
Can you rephrase? Can you just ask that question again? I'm
Yeah,
sorry.
sure. So if there's blood in a vial,
Yes,
I've shaken your hand, and then
Yes.
I touch that vial,
yes.
you're saying it's possible that your DNA would end up on the exterior of that vial.
You and I shake hands and you touch the vial. It's possible that my DNA from your hands could end up on that vial, yes.
And you use the word possible, and I think you also use the word may, but you don't know.
When DNA ends up on an object, it's not possible to tell how that DNA or when that DNA ended up on an object. That's
So it's
correct.
possible, but not probable, right?
I don't, I wouldn't give a probability of it because there's no probability statement that can be made from that. So statistically,
You don't know.
it's not possible to come up with a statistical
And
statement.
you'd agree, no matter whether it was your DNA possibly on it or my DNA possibly on the outside of that tube, neither of our DNA is going to be inside that tube, right?
That is correct.
I want to talk to you about direct transfer. DNA can also be transferred directly, right?
Yes,
For example, if I hold the handle of a firearm and shoot someone, my DNA could be on the handle of the firearm, right?
yes,
If I hold a bottle, my DNA could be on that bottle, right?
yes.
Are you familiar with buccal swabs?
Buccal swabs, yes.
Where are they taken from?
The buccal swabs, the cells inside the mouth are called buccal cells. And so a buccal swab is basically the passing of a cotton tip or cotton swab over the outside of the cells in the mouth.
And it's taken from the mouth because it's the easiest and cleanest and most reliable source of DNA, right?
I wouldn't say the most reliable source, but I would say that it's an easy source to take samples from, yes.
Well, isn't the inner cheek and the mouth lined with epithelial or skin cells that are constantly shedding?
They are, however, in the process of doing things like kissing or sharing drinks, it's possible that one could end up with DNA from somebody else in their mouth. I would say when you say the most likely source or the cleanest source would probably be blood, because people can't really change their blood and it doesn't mix, and it's a very good source of cells. So I think blood is a better source, but it's not often taken because it requires a venipuncture. There's some safety issues in terms of personal protection.
But you'd agree that swabbing of the mouth provides DNA that has both skin and saliva, right?
I don't think that the mouth has skin cells in there. I hope it doesn't have skin cells.
Doesn't have epithelial cells that are shedding constantly?
Epithelial cells are different than skin cells. So epithelial cells are basically cells that are on the exterior of organs. So skin cells, for example, would be epithelial cells. Buccal cells would be epithelial cells. So yes, the mouth does have epithelial cells, just not skin cells.
I want to talk to you about Exhibit 30. Attorney Scully asked you some questions about this item, right? 20. Exhibit 20.
Yes.
You know what that is?
It's a Powerade bottle with a cap.
You'd agree with me that to drink from that bottle, you have to remove the cap, right?
Yes.
And the mouth of the bottle is inside of that cap, right?
Yes.
Could you remove the cap?
Yes.
You'd agree with me that the inside of the cap isn't exposed until you just remove that cap, right?
That is correct. Yes.
The area is covered when the cap is closed, right?
Yes, ma'am.
It's not exposed to the casual contact of the environment unless that cap is removed, right?
Yes.
Someone wouldn't touch that area unless they opened it, right?
Yes.
You'd agree with me that not only does the cap of a bottle prevent spilling, but it also protects the area of the bottle you drink from, right?
Yes.
You'd agree that it acts as a barrier between the outside world and the drinking surface.
Yes.
To drink from that bottle, a person would need to place their mouth on the opening, correct?
Yes.
Their lips would make direct contact with the rim,
Yes.
and that's how most people drink from a bottle, correct?
Yes.
So the mouth of the bottle is in the exact area someone's lips would touch when they're drinking it.
Yes.
So finding DNA there is consistent with someone drinking from that bottle, right?
It may be consistent with that. Yes.
You said that you agreed with the results of the Massachusetts State Police Crime Laboratory in terms of their DNA analysis and their statistics, correct?
Yes.
I'm going to show you what's been marked as Exhibit 61. So you agreed that the DNA of Leroy Fowler was 9.96 trillion in favor of his DNA being present on the exterior of the Powerade bottle, right?
The statistical statement you gave needs to be read in full. I'm happy to read the statistical statement. I don't disagree with the Commonwealth's report.
So you agree with the statistics, and this is a large amount of DNA that was present, correct?
It was not a large amount of DNA present.
It was a full profile, right?
It was a full profile, yes.
And you agreed that Barbara Randall was excluded from any part of that bottle, right?
I do.
I have no further questions.
Mr. Scully.
No further questions. Thank you very much.
Thank you very much, Dr. Lakin. You may step down.
Thank you. Thank you. Your Honor, do you want me to?
You can just leave that right there. Thank you, sir. Does the defense rest?
Judge, defense would move.
Oh, I'm sorry. You go ahead, Mr. Scully.
Thank you, Your Honor. Defense would move in the next exhibit. I believe there's no objection. This is the deed to the property in Florida, and I'm looking for the address at 3965 East Lake Park Drive, Hernando, Florida, owned by Judy Church.
All right, then that may be admitted as our next exhibit. I take it there was no objection?
No objection.
Exhibit 67, so marked.
And with the court's permission, may I
Read some medical experts.
publish this to the jury
Oh,
briefly?
yes, you may.
So this is exhibit 67 on the screen. Okay, Your Honor. And lastly, with the court's permission, we have several entries from medical records of Mr. Fowler would like to read to the jury.
Yes, you may. Jurors, yesterday, just as I allowed Mr. Camilio on behalf of the Commonwealth to read a few excerpts of some notebook entries, all of which are part of the evidence in this case, have been admitted as exhibits and are available for you to review. I'm going to permit Mr. Scully to highlight a few passages in medical records that have been admitted as exhibits, are available in full for your review, but he's going to read a few passages, and I think in each instance he'll identify the medical record and the date. Go ahead,
Yes,
Mr.
I
Scully.
will. Thank you, Your Honor. These are all from Exhibit 8.
Also non-dramatic reading by Mr. Scully.
Best I can, Judge. Thank you. So from Coastal Medical Associates, Leroy Fowler, November 13th, 2015.
Would you tell me that date one more time, Mr. Scully?
November 13th, 2015.
Thank you.
Anxiety, chronic problem, insomnia, chronic problem. From Coastal Medical on April 28th, 2017. Abdominal pain of unknown cause. From Coastal Medical on July 11, 2018. Past medical history, depression. From Coastal Medical, August 27th, 2019. Treatment number 6, bipolar 1 disorder. September 30th, 2020, Coastal Medical. Assessment, hypertension due to drugs. And lastly, from June 13th, 2022, Dr. Shane, Office of Dr. Shane Murray, history, chronic lower back pain, abdominal pain, impression, moderate constipation. Thank you, Your Honor.
Thank you. And with that, Mr. Scully, does the defense rest?
Bench rest.
Thank you. Jurors, we are going to take a recess. We'll allow the attorneys to collect their thoughts. And when we reconvene in about 20 minutes, we will proceed to some preliminary or pre-closing instructions by me, and the closing arguments, some additional instructions by me, and then deliberations will begin. So we're going to take that break right now, give counsel, as I say, a chance to collect their thoughts and get ready for the
All right. Court is back in session. May be seated.
Thank you. Mr. Scully, you have a motion.
Yes, Judge, may I approach?
Yes, you may.
I think I printed this the other day, so it says 326, but I am happy to make argument, but also waive argument at this time.
All right. Thank you, Mr. Scully. The motion for a directed verdict has been renewed at the close of all the evidence. I do not find that the Commonwealth's case, viewed in the light most favorable to the Commonwealth by the jury, has degraded through the presentation of the defense case to the point where it changes the determination that I previously made, which is that the evidence is sufficient, construed in the light most favorable to the Commonwealth, to satisfy beyond a reasonable doubt the elements of the charged offense of first-degree murder on both theories. And so I therefore deny the renewed motion, and we'll take that recess of 20 minutes or so, and then we'll reconvene for instructions and closings.
Thank you.
Thank you all.
Court, all rise. Judge, I'm sorry, before we go, one thing.
Yes.
At the beginning of the trial, there had been some discussion about expert testimony that ethylene glycol could be a substitute for cocaine or used for various things by a cocaine addict. None of that came in during the course of the trial. So I would just ask that the court instruct the defense that they cannot argue that in the closing.
Mr. Norkunis?
Judge, I think the medical records are full of, he has polysubstance abuse from both tobacco and cocaine, or within each of the 3 medical records. They're also in his own personal medical records, which are all now exhibits within this issue here. I don't think that I was going to rely significantly on that, but I think that my memory is testimony did come in from several of the civilian witnesses about his cocaine use in here, I believe. I think it was Mr. Hawkins, if I'm not mistaken, had talked about it.
There's certainly evidence. There's evidence about Mr. Fowler's cocaine use. Mr. Camillo is correct to my recollection, and I was listening for it. I didn't hear any competent medical or toxicological testimony by any witness that, for example, someone in the throes of cocaine withdrawal, if they have a substantial substance use disorder with respect to cocaine, might seek out ethylene glycol and intentionally ingest it. We had that discussion during the motions in limine, where I made plain that I would not permit that to be argued unless competent supporting testimony was presented, so that the jury would have a basis for drawing such an inference. It has not been presented, so I won't permit that argument. That is that the jury might find that Mr. Fowler would have intentionally ingested a mixture, a drink of some kind with ethylene glycol because he was experiencing some sort of cocaine withdrawal. That's not permissible because there's no supporting evidence.
I don't intend to make that type of statement, Judge. My statement that's in my notes here would be, he's at one of the most climactic moments of his life. The medical records show you that he suffers from depression, he's bipolar, he has polysubstance abuse, he has a pacemaker. The hospitals indicate that also his use of cocaine and cigarettes are a concern.
That's all evidence before the jury. I don't have an issue with you saying those things.
It's not my, and that's the position.
Mr. Camillo just wants to make sure that you're not taking this that one step further, because if you did, he'd have to object. I'd have to strike it, which is, just as I've just said, which is to suggest to the jury, someone like Mr. Fowler, who may have been abusing cocaine, you might find would have sought out ethylene glycol. There's no basis for the jury to draw such an inference, because there's no supporting medical testimony of any kind that people who may be cocaine users do such things.
I'm not going to say what other people knew. I'm going to say what condition he was in. One of the most climactic moments in his life. He's at the hospital and he has EG. There's testimony from many witnesses that have said people on their own do consume ethylene glycol. I think Mr. Camillo just asked Mr. Crouch about that.
That you may argue anything that's in evidence, and in the fair inferences from the evidence that doesn't require some expert testimony that hasn't been adduced or presented. So, I'm not going to micromanage the closings. This was one particular issue of concern to Mr. Camillo. You're not going there, and that's fine. Okay. Thank you all. So we'll be in recess, and then we'll reconvene.
Court, all rise. Court
All right. Well, it looks like, June, there is your answer. The defense has rested and she is not taking the stand. They have been given roughly about a 20-minute break to get their thoughts together. Then they will come back in. While we are waiting, I'm going to go ahead and get us over, and we're going to start the beginning of day 2 recap for the dentist behind the door trial, Georgia versus Suzanne Miracle. And then when this trial comes back from their break, we will resume back with this trial. So let me get this over for you guys, and we will get back into trial for the recap.
Good morning. Welcome back. Good morning. All right. Welcome back. Thank you so much. Please be seated. Thank you so much. We'll continue with examination of the witness from yesterday.
Can you hear me okay?
Yes.
Okay. The first thing I want to talk to you about is your work at the hospital on the night of the shooting on March 8th, okay?
Okay.
You went to the hospital with the deceased's body, in essence, right? And collected some items from his person.
Yes.
Okay. One of the things that you collected was a set of keys.
Yes, sir.
First witness.
Yes, sir.
Show me your defendants too.
Yes.
Is this the photograph you took of the keys?
Yes, it is.
Okay. I'm going to tender defendants too.
Two is admitted. Thank you.
Permission to publish?
Yes.
You can see it here. Let me see if I can zoom in some. At the tail end of the keys, we see the Kia emblem, if you will.
On the key fob. Yes.
On the key fob, I'm sorry. Thank you for correcting me. Okay. On the key fob, you see the words Kia.
Yes.
Okay. When you got to, now we're going to the residence now, okay, 4238, okay?
Yes.
When you got to the residence 4238, there were two vehicles there.
Yes, sir.
One of them was a Porsche
Yes.
and one was a Kia.
Correct.
And your understanding, of course, is the Kia was owned by Mr. Barron.
Didn't run a search on them, but I understand that that was his vehicle. Yes.
Okay. The next day, you went back to 4238 to take photographs.
Yes.
In other words, the night's over, you've gone back, it's daytime, and you're at 4238 to gather more evidence, take photographs, things like that.
Right.
And at this point, there's only one car that's still there, correct? The Porsche.
Yes.
Okay. Kia's gone, Porsche is still there.
Yes.
You didn't make any, and I don't think you did, I'm not trying to trick you or anything, you didn't make any investigation into the operability of the Porsche.
No.
Okay, in other words, whether it would run.
No, I didn't.
Okay. Something else that was in Mr. Barron's pockets that you collected was his cell phone.
Yes.
And can I first witness? I think this one might be it, right?
Yes, that's my understanding. That's the one that came from the hospital. The one from the scene had a blue case.
Right. There were, in this case, there's two different cell phones involved, right?
Right.
One has, can I publish 179, Judge? Sorry, well, it's already.
Yes.
This is states 179, and I'm going to back up now if I can do it. And turn it the better way here. States 179 is Mr. Barron's cell phone that you collected at the hospital on the night of March the 8th.
Yes, it came from the hospital with his possessions.
And it has this kind of, I don't know, what we'll call that, maybe tan or clear kind of case on it.
Yes.
Now, the next, well, we make totally clear about this. There's the other cell phone that's involved is Miss Miracle's cell phone.
Yeah, I didn't actually run anything on the cell phones. I've got two cell phones I collected. The one that we're looking at in this photograph came from the hospital. The one that was in the blue case came from the scene.
Right. And it came from a very specific place in the scene. Approach witness. Showing you States Exhibit 96.
Yes, sir.
And may I publish, Judge?
Yes.
It's already been. On States 96, we're looking at the blue cell phone. You don't attribute that to Miss Miracle, but the blue cell phone that's at the top of the stairs right outside the room where the shooting happened.
Yes.
And approach the witness, Judge.
Yes.
Showing you States Exhibit 99.
Okay.
That's your lab photo of the
same phone, yes.
In other words, not the night of, but later photo that you took of the phone. May I publish 99?
Yes.
Turn it some so you guys won't have to look sideways. Like some cell phones have notifications you can give yourself to do certain things, timers that you build into your calendar and things like that, right?
Yes.
And we've got two kind of pop-ups on the blue phone. One of them is a push-ups notification, and the other one's something about squats.
Yes, sir.
Okay. Now I want to talk to you about the two different types of rounds or bullets. I'm going to use the word bullets, but the correct word is rounds, right?
Whichever one you want to use.
All right. Which one would you prefer?
It depends on what you're talking about.
The whole thing.
The whole thing I'll refer to as a round. You can refer to it as a bullet.
A round meaning the whole thing. It means the shell, which is the outer casing.
The casing.
The bullet, which is inside of the actual casing.
Correct.
And then whatever the cover is over the bullet or the lead, whatever the casing over that is.
The jackets, yes.
The jacket, okay. And in this case, we have two different types, right?
Correct.
One of the types is the type that was in Mr. Barron's Beretta.
Correct.
And you've referred to that as a Hornady.
Hornady, yeah.
Hornady. It's the brand.
It's the brand name, yes.
It's a brand name, but it's a style of bullet. It's a style of round.
The
type of round.
Type of round, yes. I mean, you've got the Hornady, which was a hollow point round.
Okay. And I just want to make sure we're all on the same sheet of music about what that means, okay?
Okay.
So you've got Hornady, which is a brand, but it is a hollow point round.
The rounds in the, yes. I mean, Hornady makes multiple rounds, but what we're looking at in this one is a hollow point round.
This one,
Yes.
we're talking about hollow points. And it is and was associated with the Beretta.
Correct.
The Beretta is not the gun that ended up ending Mr. Barron's life.
Correct.
The other type of round that we have in this case is a Jag.
The brand is Jag, yes, or
It's a Jag brand, but it is a full metal jacket.
it's a full metal jacket. And I don't want to get real picky with the Jag. When I was trying to research, Jag is just a manufacturer. It's not necessarily coming back to a specific brand. That brass can be manufactured for multiple different companies.
Is this sort of a cheaper bullet, if you will?
I'm not sure. I didn't locate any Jag ammunition to.
But generally, a hollow point's a more expensive round to buy than a full metal jacket.
Yes,
People use full metal jackets for things like target practice.
correct.
In other words, if you go to the range, that's what target practice means, right?
Correct.
This is not good writing. The Jag round, the full metal jacket round, the target practice round is inside of the Glock,
Correct.
right?
Yes.
And there's really no question here about how many shots were fired from the 9mm Glock pistol, correct?
Correct.
We've got one shot.
One round that was recovered, yes.
One round that's recovered and one round, as far as you know, you don't have evidence of that 9mm being shot any other place. Is that
No.
correct? Okay. This is the shot that came from this full metal jacket round and went through this door then through, showing you states 5. It's already admitted judgment published.
Yes.
This is the round that went through here. I'm trying to get this thing closer if I can. Let me back it up. Through the door, through the wall edge there, and then eventually struck Mr. Barron.
Yes.
If that shot had been shot with a hollow point bullet, gone through that door, then through that wall, we're talking about a different type of an impact. Fair guess.
Possibly, yes.
Possibly may not even have killed Mr. Barron.
It depends on how well the bullet actually stayed intact. The hollow point is designed to expand and open up, where the round full metal jacket is designed to go just straight through.
Exactly. And you can't recreate this and come up with, a certainty here. But the fact of the matter is, if this had been a hollow point, it may not have killed Mr. Barron. You don't disagree with that?
It could have, because it's a hollow point, it could have expanded out when it went through the wall and went through the door, and it could have had a different velocity on impact. So
now, we know, again, that this Glock shot one shot, right?
yes.
Question is, how many shots came from this Beretta? That's what I want to talk to you about, okay?
Okay.
Now, correct me if I am wrong, but I think you said yesterday that you think there were 3 shots from the Beretta.
Yes.
Okay. One of the shots, the shell, was actually still stuck in the barrel of the Beretta.
Still in the chamber, yes.
It was still in the chamber.
Yes.
And when you got there, you are dealing with that firearm and you discover you've got a firearm with the shell still inside of the barrel.
Chambered, yes.
The chamber. Okay, thank you. There's a shell still inside the chamber. We know that that shot was shot, obviously, because it doesn't have its bullet.
Doesn't have the projectile, the missile, yes.
Doesn't have the projectile.
It's a fired round.
It's a fired round. For sure that was fired. It's still stuck in the gun.
Yes.
And we think, based upon your review of the scene, that you've got 2 more shots.
Yes.
Okay. And whoever fired those 3 shots, whoever fired those would presumably know how many shots they fired. True?
Yes.
It's been proposed that Miss Miracle was staging the scene by firing these shots. You understand that that's being suggested? If she's staging the scene to make it look like Mr. Barron has fired at her 3 times, why does she tell the police that he shot once?
I'm going to object.
I'm
That
not-
calls for speculation as to what was on the defendant's mind and not, maybe it could be rephrased, but I don't think that's the appropriate form of that question.
Are you aware how many times she said?
Okay, so I'll sustain the objection. You can go at it another way.
Are you aware how many times she said Mr. Barron shot at her?
No, I'm not.
Okay. I want to talk to you now
All right, the judge is taking the bench. We are going to get this one started for you guys.
Record with case on trial and jurors are lining up.
Here we go. I do. No, but I just got brought some, that's a tea.
All good, Madam. Bring them right in.
All right for the jurors? Be seated.
Jurors, you've all been provided with a copy of my written jury instructions. So I see all of you have them in your hands. Before I begin, I just want to make a few observations. First, I'm going to read these instructions to you verbatim. I do that with an understanding that that can be a fairly stupefying experience. But I do that because under our rules, if I read the instructions to you verbatim, I'm permitted to provide you a written copy of them. And so that's why I have to stay completely on script. That's why you're able to have a written set of instructions. Second, with respect to those instructions, I do my very best to proofread them and catch all typographical errors. I hate the thought of my work going to a jury with some typos, but inevitably, as I read the instructions, I spot some. And if that occurs, you will typically see me correct them on the fly. Finally, there are a number of headings and subheadings in these instructions. I don't read them. I read only the text. But the headings and subheadings are available to kind of organize the material. And during your deliberations, if you wish to find some portion of the instructions, it may make it easier for you to do so. So with that, we'll see how I'm able to proceed, but we will proceed. Jurors, thank you for serving on this jury. Jury service is a very important part of our democratic self-government. You are responsible for upholding the law and our principles of justice. That is what you all promised to do at the start of this trial when you took your oath as jurors. You must carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt the single charge that is before you. The final part of this trial will take place in 3 steps. First, I will give you instructions about the law for the specific charge in this case. Then the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and argue in favor of the conclusions that they ask you to reach. After the closing arguments, I will give you general instructions that apply in every case. 4 of you will then randomly be selected to serve as alternates. The remaining 12 jurors will then work together in private in what we refer to as deliberations to reach their verdict. Please pay close attention to my instructions. All of my instructions are important and you must follow all of them even if you do not agree with them. To make sure that I give you the instructions accurately, I will read them to you. You've each been given a written copy so you can read along as I deliver them if you choose to do so. and that is up to you. And you will have your copies of the instructions with you during deliberations so that you will be able to refer to them at that time if you wish to do so. If you do read along, read along right now as I deliver the instructions, I ask that you not skip ahead. Rather, please read each line as I deliver it orally. I will do my best to make sure that the instructions I now give when speaking match the written instructions. If there's any difference between what I say aloud and what the written instructions say, please follow what I say aloud. I'm now going to address the fundamental constitutional legal principles that apply in this and all criminal cases. In doing so, I will be repeating and to some extent expanding upon what I told you during the impanelment process and in my earlier instructions just prior to the opening statements. The defendant, Judy Church, has been charged with the offense of murder in the first degree of Leroy Fowler. I will refer in these instructions to Mr. Fowler either by name or as the deceased. Every person who is accused of a crime is presumed to be innocent of that crime. The defendant, Ms. Church, is presumed innocent of the charge that has been brought against her in this case. Thank you. That means that you must consider Ms. Church to be innocent of that charge unless the prosecution has proved beyond a reasonable doubt through evidence presented during the trial that Ms. Church committed the offense. I will explain what I mean by reasonable doubt in just a moment. As a defendant in a criminal case, Ms. Church does not have to do anything to convince you that she is innocent of the charge against her. She does not have to explain anything. Ms. Church does not have to testify, call, or even question witnesses, or provide any evidence at all because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charge against Ms. Church beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Church's guilt, then your verdict must be not guilty. You may find Ms. Church guilty only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. And you may find Ms. Church not guilty only if all 12 deliberating jurors agree that the Commonwealth has failed to prove the charge beyond a reasonable doubt. In other words, as I will discuss again later, regardless of what your verdict may be, it must be unanimous. You have observed that the defendant, Ms. Church, did not testify at the trial of this case. As I told you during impanelment and again in my initial instructions, she had an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Again, it is not up to a defendant to prove that she is not guilty. You may not assume or infer that Ms. Church's decision not to testify suggests that she is guilty of any crime. Simply put, that decision by her is not evidence of anything. The fact that Ms. Church elected not to testify is in no way to be regarded by you as involving the question of her guilt or non-guilt as to the charge against her. You may not draw any negative inference from that decision, so you are not to discuss it or consider it in any way in your deliberations in the jury room. You must determine whether the Commonwealth has proved its case against Ms. Church based solely on the testimony of the witnesses and the exhibits and evidence in the trial of this case. Let me just stop for a moment. It just occurred to me, thinking about the evidence in this case, counsel, that you may not have, we may not have read to a jury stipulation that I think counsel had entered into. Is that correct? We discussed it yesterday afternoon.
Or not, Judge. I can do
We did not, but it's part. We all agree it's part of the evidence, correct?
Correct.
All right. So that is marked as what exhibit?
66, Your Honor.
66. All right. And it need not be read now, but I just will tell the jurors that Exhibit 66 was a stipulation that counsel have entered into in this case. I meant to read it to you this morning. I did ask counsel to remind me. We all forgot. But I want to make sure that you read that stipulation and understand that that's part of the evidence before you. Getting back to the instructions on page 6 under the heading Proof Beyond a Reasonable Doubt. As I have now repeatedly told you, the burden is on the Commonwealth to prove beyond a reasonable doubt that Ms. Church is guilty of the charge made against her. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted, that is, found not guilty. It is not enough for the Commonwealth to establish a probability, even a strong probability, that Ms. Church is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of Ms. Church's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. The Commonwealth has charged the defendant, Judy Church, with murder in the first degree. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on two alternative theories: murder with deliberate premeditation and murder with extreme atrocity or cruelty. To find the defendant guilty on either of these theories of murder, you must be unanimous. That is, all 12 of the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict form as to each theory on which you would agree unanimously. I will discuss the verdict form with you more fully later. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt either of these two theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I will begin by instructing you on the elements for each of the two theories of murder in the first degree. I will then instruct you on murder in the second degree. I start with the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt each of the following three elements. First, that the defendant caused the death of the deceased. Second, that the defendant intended to kill the deceased. That is, the defendant consciously and purposefully intended to cause the deceased's death. And third, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. I will now discuss each of these requirements in more detail. The first element is that the defendant, Ms. Church, caused the death of the deceased, Mr. Fowler. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant intended to kill the deceased. That is, that Ms. Church consciously and purposefully intended to cause Mr. Fowler's death. If you have a reasonable doubt as to whether the deceased's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find the Commonwealth has proved this element of intent to kill the victim. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Next, I will define the elements of murder in the first degree with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless of whether or not you find that the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove each of the following three elements beyond a reasonable doubt. First, that the defendant caused the death of the deceased. Second, that the defendant either A, intended to kill the deceased, or B, intended to cause grievous bodily harm to the deceased, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of the deceased. This is the same as the first element of first-degree murder by deliberate premeditation. As I've already explained, a defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death and without which death would not have occurred. The second element is that the defendant, A, intended to kill the deceased, or B, intended to cause grievous bodily harm to the deceased, or C, intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to the deceased. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that the death of the deceased would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the deceased's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether the deceased's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which in the circumstances known to the defendant created a plain and strong likelihood that death would result. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of a human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's action in terms of the manner and means of inflicting death and on the resulting effect on the deceased. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. 1, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. 2, whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the victim. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the three factors I have just listed. Turning to murder in the second degree, in order to prove a defendant guilty of this, the Commonwealth must prove each of the following two elements beyond a reasonable doubt. First, that the defendant caused the death of the deceased, and second, that the defendant intended to kill the deceased or intended to cause grievous bodily harm to the deceased or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. As to the two common elements, the same instructions I've already provided regarding those two elements apply as well to the charge of murder in the second degree. I'm now going to see counsel very briefly at the sidebar, and then I will have a few brief remarks about the closing arguments and we'll proceed accordingly. Jurors, why don't you stand up for a moment and stretch, shake out the cobwebs a little bit. I want to make sure that you are completely alert for the closing argument. We're now going to proceed to the closing argument stage of the trial. This is an opportunity for each of the attorneys to sum up for you the evidence you have heard and suggest to you how you ought to view the evidence and what inferences and conclusions you should draw from it. If you choose to take notes during the closings, you may do so. If you do take notes, I suggest that you draw a line across your notebook page so that you are reminded that everything that appears below the line is not evidence and should not be considered as evidence by you. The attorneys will do their very best to accurately relate the testimony you have heard and the content of the exhibits that have been admitted into evidence. But if anything either attorney says conflicts with your view of the evidence, you are to disregard it, as it is your collective memory and view of the evidence that controls. Bear in mind as well that it is impermissible for either attorney to express any personal opinion about the evidence or about the credibility of any witness. I do not expect that either attorney will do so. But if either attorney uses any phraseology that might suggest that he is expressing some personal opinion, such as the words, "I think," you are to regard the comment as one solely suggesting how you should view the evidence, and not as an expression by the attorney of his personal opinion. Because the Commonwealth bears the burden of proving the charge it has brought against Ms. Church, Mr. Camilio, the prosecutor, went first at the opening statements phase of the trial, and he will go last now. So you will first hear from defense counsel, Mr. Norkunis, on behalf of the defendant, Judy Church. Mr. Norkunis, the floor is yours.
Thank you, Judge. Good morning, ladies and gentlemen. I'm here now as we have come to that conclusion of the case. The judge said to you, each side gets to argue the evidence, tell you why their position is the correct position for you to present when you return a verdict in this particular case. You've heard from Attorney Scully, you've seen Ms. Morrissey. In this particular case, we represent Judy Church in these proceedings. Two issues, two words that we began the case with, and I think are important throughout. We talked about color and we talked about taste. We had some presentations relative to that, and I'll get to those in a moment with you. Leroy, did what he wanted and you don't tell him what to do. You just don't. This was Judy Church in a statement to the police when she was talking to Trooper Williams and she was talking to Detective Verney on November 14, 2020. Judy Church did not kill Leroy Fowler. Judy Church did not murder Leroy Fowler. Now, the court has set out for you the law that it gets applied in this particular case. I would just like to highlight as I'm beginning again what some of that is. The very foundation of our system of justice in which we operate. It's the bedrock of which our entire system is built. Reasonable doubt. This isn't just a technicality and it's not just a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove each and every element of the charged crime, in this particular case, murder, beyond a reasonable doubt, that is to a moral certainty. Those are powerful words. They're not just legal jargon. They are your mandate. They are your obligation. They're your community's protection against injustice in our system. Now, what that means is that at the end of the case, where we are, at the end of this trial, when you have the charge by the court and you are deliberating, if you think, you know what, maybe that's true. It might be true. And you have to vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true, even if very likely true, your vote still must be not guilty, because none of those standards, none of them might be, could be, possibly, very likely, none of those meets the extraordinary burden of what beyond a reasonable doubt to a moral certainty needs within our criminal justice system. Now, this case revolves around the relationship of the church in the Leroy Fowler. And the Judy Church, a mother, a sister, a homemaker, an educator. She laid those all out for the police when she gave her second statement on November 14th. She told Trooper Williams about her long career as a fourth grade teacher in Middleton, Massachusetts. She was married when she first encountered Leroy Fowler. He came and he rented a room or unit from her at their home in Salisbury. Soon, they became a couple. They were in love. Husband left. Husband, I believe the name you've heard was Rusty. He left. And at that point in time, then, I might show you these. These have been introduced as exhibits in this particular case. The next one, please. In 2012, then, Judy and Leroy set up a home and they started to create a life together. Judy had financial security. She had the house. She had the full-time job. She was healthy, vibrant, and smart. Then they cruise along in that same mode. And then in 2016, 2017, someplace in that time frame, Leroy began a second relationship with a woman named Barbara Randall. Also about that time, and you have the medical records of Leroy here, he started having a number of medical issues. You have his medical records from 2016 to 2022. The health continued to spiral downwards up and through November 14th, 2022. And again, you'll have those available to you. You can see what they set out for you. Physically, at times, he had chronic pain syndrome. He had a pacemaker. He had Achilles problems. He had stomach issues. Mentally, he had depression. The records show he had bipolar disorder and anxiety. And at that point in time, the evidence is being presented to you. He was not working. He was on perhaps Social Security disability, but he had no financial independence. And what also is indicated in there, he was polysubstance abuse issues. He was using cocaine. And an emerging issue, perhaps, with alcohol from some of the evidence that you've heard. At one point in time, Leroy had a temper, and at one point in time, he got into a physical altercation with Barbara Randall, and that was in the summer of 2022. Pulled her hair, threw her to the ground. Things were not getting better for Leroy at that time. He had some blackouts that had been reported, and and his position seemed to be getting physically worse. Over the years, as the couple progressed, Judy had bought 2 motorcycles for Leroy and a pickup truck. He did become dependent upon her as his principal source of income. But the actions of Leroy Fowler were somewhat consistent. You had heard from Michael Hawkins. Michael Hawkins told you that his mother was named Julie Hawkins, and Leroy had been living with them. Then at some point in time, when he had met Judy, Leroy moved out on Julie Hawkins and moved in with Judy Church. And then he would be, according to Michael Hawkins, come back for visits was the term that he had used. I would submit to you there would seem to be a particular pattern of the way Leroy Fowler was leading his life in terms of associations with women. And then he takes on a life of his own. His agenda was the agenda that he made as once he became, this 2017, I believe the evidence was from Barbara Randall, that he began an association with her. And it was an association where he went over a house, stayed there. You can believe they were living as a couple. It's reasonable to infer from what you have heard. At the same time, he's still living with Judy Church. And at that point in time, and I think there was some indications from some of the evidence, obviously Judy Church was hurt. I'm assuming at some point in time, Barbara Randall was hurt. He's splitting his time between both. He's abusive, therefore, emotionally to both women at the same time. There is no particular, they show flashes of anger but they blame each other. Neither one of them is blaming. Text messages you have available to you is blaming the Leroy. They had even came out with nicknames for each other. And you heard those from the testimony here. I won't repeat those here today, but it denigrated to that situation. Again, the person that was causing all of this, they didn't share their anger at, they did it towards each other at that point in time. Judy would channel her anger at times, and you have a couple of the journals, they're undated, but she would journal her anger about what Leroy was doing, a way to get rid of your hostility without taking out any action against the person. She would put down what she saw and what was there. But Judy constantly expressed her love for Leroy, despite what was happening to her, and it does get angry at times. Tammy Carbone, Leroy's sister, testified she became friends with both women during this period of time. She testified Leroy did not have the means to pay for his own life, and he had his health problems. As previously mentioned, Leroy III, the son, was out trying to give some work to his father. I think he said he gave one construction job to them. The important aspect of that is he still could go out and do work. You heard about, through the statements of Judy Church, which we'll get to in a moment, to the police, that Leroy was doing work around their homes, that he was building, trying to build a floor underneath. So he still had his, he was still active physically. Michael Hawkins took him to work on a grow facility for 3 days up in Vermont. And, he was active as physically there as well. Get up there. He indicated that at some point in time, Leroy III, that he even had a restraining order against his father in 20 and 21 due to physical issues that he had encountered with his dad. Leroy III, the son, also had a relationship with both Judy and Barbara Randall. There's crossing roads at all times. The years move on for the triangle that is composed of Judy Church and Leroy Fowler and Barbara Randall. Nothing of any hostility between the women themselves, physical hostility. There are down times, there are messages expressing feelings, there are partial breakups, but Judy continues to express her love for Leroy. She gets very hurt, she indicates, when at one point in time, when she sees Barbara sitting on the back of a motorcycle that she bought for Leroy. And at that point in time, she went out and bought him another motorcycle instead. Now, when you move into January of 2022, the couple, Leroy and Judy Church, go down to Florida. They buy a home. There's a deed here showing that they actually bought the home in Florida, and it's under both of them. It's under both their names, tenancy by the entirety, which is normal when there's a couple together within it. And Judy is pushing Leroy to join her and come, and they're gonna move to Florida. It gets delayed, and finally in mid-November, they're packing up, they're going. You saw the house, pictures of the house. Everything seemed to be in disarray as they were packing up and getting ready to leave in the house. They had bought a van. William Eaton talked to you about a second van they were looking at to get so they could move to Florida. In that mid-November timeframe is when all of the dreams of Judy Church are coming true. Barbara's going to be behind. Leroy Fowler is coming with her. They've got a residence, a home in both of their names in Florida, and they're moving there. There are text messages of evidence showing that Leroy and Barbara had ended it, the hostility between them, the words that were done. I believe they were from November 5th or 6th, but you'll have those with you in the jury room to look at within this. That Judy, when she's talking to the police, says that she believes when they're down there, Leroy can be drug-free because she believes, but that she has no basis for it necessarily, but she believes that Barbara Randall was the source of Percocets for Leroy. And now in Florida, the drug issue would be left behind and they will be all set. Now, Leroy had particular drinks. Everybody said he had a sweet taste in what he liked to drink. He liked to drink Fanta, orange soda, and he liked to drink fruit punch, red, Powerade, and coffee fraps or milkshakes made for him by Judy in her blender. At some point prior to 2022, it became a family joke that originally started perhaps by Leroy, that in giving the milkshakes to Leroy, she was trying to poison him. Now, if you jump forward to the police search, they take the blender out of the house. They don't do any testing on that. But that was the position that the family had, that he was getting poisoned through family milkshakes made in the blender of her home. They seize the blender, but they don't touch it. They don't test it to see if there's anything there. Now, in the weeks leading up to November 11th, family and friends speak and see Leroy and express opinions about how he feels and what he looks like. Now, Michael Eaton said he talks with him about the van, sees him about a week prior regarding the sale of the van. He said he looked fine, sounded fine, and seemed to be happy about and speaking about moving to Florida. Now, the day that the government says that Judy Church stepped forward to murder Leroy Fowler Sr., she did so by putting ethylene glycol in a Powerade bottle. All of the evidence of that time shows that, again, the dreams of Judy Church have come true, that everything is working well at that point in time. The government has no evidence in this particular case, direct or even circumstantial, that things were a rise on November 10th, November 9th, November 11th. And yet, they want you to believe that she purposely and deliberately set out to murder him. Not harm him, but murder him at that particular date. The circumstantial evidence supporting that is so minimal, ladies and gentlemen, in this particular case. Now, Leroy is up most of that night, according to what Judy says, and we'll get to her statements to the police in a moment. And he has a consistent message, and he is, and I'll go over this probably several times. He's doing text messaging. So I'm absolutely sure going at text messaging. They are somewhat, pornographic going forward, but there's a consistent message from 1 a.m. through 5:30 a.m. So the thought process is working here, and then he's doing it on a cell phone. Everybody has done that. And what is your keyboard on a cell phone? 1 inch high by 2 inches wide. And for most men, larger hands, larger fingers, you've got to know what you're doing, and the message goes through. It's possible some of those, there's some misspellings or misstatements on it, but it shows a consistency of mental alertness, physical dexterity in this particular case. Why is that important? Because you've heard a lot of evidence in this case about what ethylene glycol does. Ethylene glycol has a timeline. Even with Mr. Crouch here today, statements from and questions from Mr. Bilio, it's a timeline. There were 3 stages they talked about. The doctor from Mount Auburn also told you about the half-life of ethylene glycol and what happens when that is consumed. And jumping ahead into Mr. Crouch's statements to begin with, he talked about the quantity that would be necessary for a person to consume to be able to have, considering those other factors, ethylene glycol, you've heard words metabolizes, become acids, anion gaps, and as molar, whatever. The ethylene glycol disappears, and that's the toxic substance come in, but it moves quickly through the system. He had 28 grams in his system still at the time he went to Anna Jake's hospital in Newburyport. That again, I would submit to you when you analyze the timeline, it's consistent with someone that's doing it themselves in the evening. He would have to have consumed to get to that, somewhere around 2 or maybe a little more 20-ounce Powerade bottles itself. Whatever may have been in them and however it got into them. Now, at some point in time then, Anna Jakes decides that they can't treat Mr. Fowler as he's there. When you first look at what happens, you had the videotape of the officer that responds to Laria and the EMTs and the fire department that gets there. And what do? They come in and it's clear and obvious that they believe he's ODing. They're in no hurry. They're talking to him. They're doing something. The officer took the stand to counter Mr. Lemke, one of the EMTs, who had said that Leroy said to him something in the neighborhood of either I took 2 perk 10s or I took 10 perks, but he made a statement to it. The officer's presentation is, well, I didn't hear it. When you look at it, what you're going to see is, as where I am here, he's outside the door. The 2 EMTs are inside. Judy's in the bed talking. They're bending down to hear the man. This officer said, I didn't hear it. Because you didn't hear it, it didn't happen. Mr. Lemke was certain it happened. He said it. believe he told you that he repeated it inside the ambulance itself. What's important about that is he didn't say it's what she made me drink. I was poisoned. It's what it was the liquid that I drank. It was the milkshake. None of that came in at that point in time, a critical stage of his life at that point. And he's not saying anything other than he believed it was something that he took on his own. And I think that is absolutely critical. What happens after that is it seems to take on a life of its own, the investigation, not driven by investigators, but put together as the family believes that something happened because Leroy said over the years, I think Judy's poisoning me. Part of it also is you've heard about the timeline and you've heard about what happens if you get to someone within who has ethylene glycol poisoning and you get to them within a reasoned period of time. Maybe they're going to be pretty good. He sits in Anna Jake's 12 hours, I think it was what the nurse said. And then at some point in time, he gets moved to Mount Auburn. Mount Auburn decides they cannot do it. They do a dialysis, but they can't really help him anymore. And then they send him over to Beth Israel. Now, if I can sneak by here for a moment. Within the records you're going to see of Beth Israel Hospital itself, and you'll have those with you and be able to read them. There is the statement that I had the ME read to you, in which the doctors treating him, the team treating him, said this is an unusual case. There is an issue relative to whether he actually has ethylene glycol poisoning or what is causing his death. He ultimately dies of a stroke. In this particular case, the family now gets together, the family, and what you have within that is you have Tammy Carbone, you have Leroy III, and you have Michael Hawkins all together and go to Mr. Eaton's house, and they call the police to come there. How unusual is that? The police are going to go talk to the family all collectively together at the house. As a result of that, the family tells them about the joke. She's been poisoning me. They figure, that's it. We know what we've got. Let's go. Off they go to speak to Judy Church herself. That's the interview that takes place on her own property. She meets with them. You have the video. You're able to see that. She's not expecting the police. She comes home with a pizza. She's genuinely concerned and afraid when they tell her, why are you here? And she believes they're going to tell her that Leroy has died. And she's upset relative to that. And they say they're there to investigate what has happened to them. I believe it's Trooper Williams who tries to assuage her emotional state and say, what we're trying to do is just find out how this came about, what happened relative to this. She cheers up several times in talking about him, walks the police around, takes them to where he had been working again, she said, that week, and what he had been doing. I think she said he was trying to replace a floor at that point in time, in the house, in the cottage that was behind the house that they had. Now, there's a second interview done with Judy. And when that second interview is being conducted, they are also at that point in time conducting a search of Judy Church's home. And as Attorney Scully pointed out so ably to you, the search seemed to be cursory. How many items weren't even looked at? How many items weren't even examined within the context of that house itself? And the essence, I think, of that is that at some point in time, after the interview with Judy Church, the Trooper Williams goes back to the house, goes into the room occupied by Mr. Fowler, looks around, and there are several containers of Fanta soda, which was his second issue that they had. And he takes one, arbitrarily looks at it and says, I'll take that one. And even he couldn't explain why he did that. He just thought he should take one out of it. The room where he had been the night before, and he had spent considerable time, and he had been doing his texting. And then that goes off to the lab. Ultimately, both matters go off to the lab at some point in time in December, out at NMS. We heard the gentleman from NMS come in and testify. And they found ethylene glycol in the solution sent from the Powerade bottle. And again, this was a fruit punch, a red fruit punch bottle. And yet what they find, and they find it in the recycling bin, is a fruit punch bottle that's orange in color. And that's the reason it calls it gets their attention. It's orange in color, and they assume, and obviously it's not fruit punch. And again, as we had said to you before, and we have repeated throughout, color and taste are two huge criteria for anybody. Anything you pick up, you go, you get a glass of milk, and all of a sudden you take a light sip, and it's sour. I'm not drinking that. I'm sorry, I'm not doing that. You look at something, it's the wrong color. You've ordered a root beer. It comes and it's orange. What are you going to say? That's not my drink. You can't do that. If you are consistently over the years drinking a red drink, you're going to look for it to be red. If it's a different color, I would submit the average person isn't going to consume it. You don't know what that is. And as in relation to, did that particular item taste bitter to Leroy Fowler? Now, again, the government chooses not to test for Beatrix. The NMS gentleman said, well, we don't do that because we don't advise it to be done. Apparently, it's a test, I don't know, costly or whatever. We had it done on behalf of Judy Church. We found a lab that would do that, and they did it. NMS certainly could have had the same capabilities or have done that. It certainly leads an investigation into why would this happen? Why would someone with that? A number of the witnesses at the request of Mr. Camilio said, well, statistics show people are still doing it. If people are self-bent on hurting themselves, yes, they could still do that. But it's put in there, and Massachusetts has a statute on it. It's put in there for a particular purpose, if nothing else, to alert you for what you're consuming. So the color and the taste are wrong in the bottles that they find where the ethylene glycol is there. Interestingly enough, the other bottles they pull out of Powerade, they don't do any testing on. Why? We don't really know at that point in time. Now, while all of that is happening, Judy goes in and gives a statement to the police. Leroy had passed away. She had done that. She comes to the station voluntarily. She's not under arrest. She's not being forced to go there. She waves, and you've heard that. You hear her voice, you hear her tone, you see her body movements. All of those things, everybody takes into account when you're seeing if somebody is truthful or not truthful. What are you doing? How are you doing it? Where are you looking? And so you can see all of that. She provides her phone password to them so they can get into it. As we all know, Apple doesn't let you get into the phone no matter what happens unless you have a password. Now, she provides her email address so that can be searched. When she's asked whether they will find anything about AntiFreeze on her phones, she says no. And they don't. Or it would have been an exhibit, certainly, in this particular case, if that had come forward. Among other things she says Leroy was her world. They lie and suggest her fingerprints will be on an antifreeze bottle they found at her home. They try and trick her, persuade her. What is she going to say? For an hour and a half, she's there and talking. They didn't find any antifreeze at the house. They never found antifreeze at the house. So I'll get to discuss with you in a minute. They never found a source for it, for whatever the ethylene glycol was that's in that Powerade bottle. But they're trying to trick her, but she's being truthful. And she confidently says her prints won't be found on it. They don't have it, and they don't. And interestingly enough, of the Powerade bottle that's here in this particular case, we've heard much about DNA and what's found on DNA on that, which I'll get to in a moment. There's no fingerprints of Judy on that. It's in the recycling bin. You would expect it probably would have been, but nothing. They don't find that on there. Now, they ask her why the Fowler family is blaming her. They put direct questions from her that you as jurors trying to determine what may happen in a case would have probably wanted to have placed before him. She explains that they've all taken the old joke, as I told you, and they've run away with it. She tells the police that they're all putting the blame on her, but it isn't her. She repeatedly says, I did not kill that man. I love that man. Now you can ask yourself, if Judy did poison Leroy, then why would she joke about it with Tammy while he was in the hospital? Remember, there was LOL, laugh out loud. I'm going to bring him a poison milkshake. And Tammy says, maybe I'll bring him one too on that. And remember, she's a very smart lady. They bluff, the police bluff, and they try and what if we test the Ninja machine, the blender? She says, go ahead. They do take it. It's in the photos you saw that what was taken by the search, and they never test it. So they're challenging her left and right, and she is 100% successful. After an hour and a half of intense grilling by two officers, she has stayed with her description of what took place and why it took place. Now, in the DNA itself, as to the significance of that in this particular case, you've heard about transfer, secondary transfer. I've touched that rail several times throughout this trial. My DNA could go home with some of you who've reached over and touched that yourselves on it. The issue about a cap, you know, I just put my cap here. Wasn't that going to pick up DNA? The issue is, why would it be on the lip? Now I'm going to put the cap back in the bottle, as most people do. If you haven't finished it in one, you always put the cap back on. Take it off again. I put it on something else. I put it back on. Transfer. Whatever DNA was there is now on the lip of that bottle. That's not any type of miracle. It's her house. Her DNA is everywhere. How many years have they lived there? It's everywhere. Leroy's there too. Now, was Leroy's not on the lip of the bottle? So the only person that was drinking ethylene glycol was Judy? No, that was a transfer issue. The other aspect you can see many times, people will take a slug of the water. You might do this. You might touch someone after that. I've done this. You've got my DNA. There's no way that that DNA has any evidence of any merit whatsoever in this particular case. I think, and I would submit to you, again, the issue within the context of this case, it's circumstantial evidence. Circumstantial evidence, I would submit to you, is never going to show you proof beyond a reasonable doubt on the most serious charge we have in our judicial system. There is nothing here that would put that together. Well, the first thing you would need is, if the government is correct, You need a motive. Why am I going to kill you? Would say Judy. Why is Judy Church on November 11th, 2022 want to murder? Not harm, not kick, not incapacitate, murder Leroy Fowler. Well, wait, Barbara's going to be left behind. That could be a reason. Maybe he was going with Barbara. No, wait, there's no evidence of that. It's just the opposite. He's told Barbara goodbye. Well, maybe he's going to move out with someone else. No, they're going to Florida. They put a house in his name in Florida. So he's got some financial gain to go and make and do, and her life is going to be successful. There's just no motivating factor here. Everything has come together finally for what should take place. Judy Church was angry at Leroy. Move out. It's my house. I get a restraining order and you're gone. How about 2019? He's been with Barbara for a year. Would you be angry and now want to kill her? How about the statement of John Haywood to show you the reach of the government and the reach of the family? 2 years later, on this issue, he comes forward. So I was in a bar, talked to him for 4 minutes, and Judy said, if he ever cheats on me, this is 2020. If he ever cheats on me, I'll poison him. Let's see. He was cheating on her all of 2018, all of 2019. When was that in 2020? How does that statement make any sense? And he tells it 2 years later, and he's related to the family. That's the overreach that the government has in this case for you. The significant overreach. So motive, we don't know. Now, how about ethylene glycol? Had anybody ever heard of ethylene glycol? If you weren't working in the automotive industry beforehand? Trooper Williams, what did he have to do to learn about ethylene glycol? He went on Wikipedia. Isn't that how he thought he could charge her? Because he's found out ethylene glycol is this on Wikipedia. But I think of more interest is the medical examiner. He's a doctor. He's coming up with causes of death. He's never had one before. What did he do? He said he went onto the computer and looked up Wikipedia. What do they find on Judy's phone? What searches? Where was she finding out? How am I going to kill him? Was she looking for cyanide? Was she looking for other substances? And it finally came up with ethylene glycol? No, nothing. So if these very learned people, one in the law enforcement, one partially ME, and then even the NMS scientist said to you, he's only had one case ever, 2000. He had to look up some stuff online. So how's Judy finding out? One, do you get on to CVS and they got a special going? Over here this week, there's ethylene glycol. Maybe it's Market Basket. Where do you get it? Do you get it pure or do you get it with Beatrix in it? How would you get Beatrix to put it in if you didn't do that? I mean, there's somewhat of an absurdity in terms of the overreach. They have never, ever been able to tell you a source that they say of the ethylene glycol. And you wonder, why do I have that up here? And that's introduced as evidence. And there's multiple pictures of another bottle of it. Because this is what they originally thought it was. This has no merit as evidence whatsoever in this case, except it was found in the kitchen of the house. None. It's not this. That's the type of distraction that's ongoing here. You're probably looking at this since I started giving this speech. What is he going to do with that? Why is that there? Because it has no value whatsoever. But it's to try and convince you that someplace in that house, she must have had something like this. We just never found it. But it's not there. So we don't have a motive. We don't have any planning. We don't have any ability to pick up whatever it is that's supposed to be there on the most serious charge of our judicial system as to why this lady would have done that. Now, just a circumstantial case is not, in terms of what is here, is not the proof beyond a reasonable doubt to a moral certainty equating to one of the most important decisions you would make in your life. Again, if Judy didn't want Leroy, get out, leave 2019, 2018, 2019, 2020, 2021, early part of 2022, and wait till everything is perfect. And now I'm going to go out and do something that most people don't know anything about and find out how to effectuate this. Now, one thing that I think has to be considered is the videos. There's 13 of those small videos, a minute apiece, that was taken on the early morning hours of that. The government wants you to view them as Judy somehow enjoying the suffering of Leroy. She told the police this was something he had done before when he OD'd on drugs. It's something that's not uncommon for people to do when there's people having some sort of problems with a family member, and you want to show them what their conduct does. So she takes them and she keeps asking him, that 29 minutes, what happened? What did you take? Do you want me to call an ambulance? Finally, when he says yes, when the police talked to her about, was there any delay in the ambulance? She said he didn't want to go to Anna Jake's. He didn't want to have the hospital an ambulance take him. But so she waited until he said that. And if it was in fact, as everybody at that moment thought, type of tape you could use, you get to Florida and you say, let's not ever have this happen again. Let's not get involved in any type of drug issue. There's no, enjoying what your discomfort is in this particular case. Ultimately, he doesn't have any physical issues. He's not cutting himself. He's not bleeding. He's not getting bruising. I think two different doctors told you that in this particular situation. So there was a purpose. There was a method. Because again, they're going, they're leaving. And then when he gets to the hospital, she's there. She's the person that goes. And again, relative to the dissatisfaction of the family, they're really, really upset that she didn't bring them and notify them before they have their meeting at the house. Now, again, your mission is not to try and figure out what happened to Leroy. It's not why we're here. You have only one function, and that is to determine whether the prosecution has proven its case against Judy Church beyond a reasonable doubt as to each and every element. Again, it's not a maybe, it's not a probability, it's not a possibility. It's to a moral certainty. And remember, this case is loaded with reasonable doubt. Pieces of the puzzle. Mr. Scully, Attorney Scully told you about that when we began. It's like a puzzle. And the government is trying to fit all the pieces in, but they're trying to put some square pieces into round holes, and they don't fit in what we have here. Now, it's impossible to think that Leroy Fowler wouldn't have noticed the color. It's bright orange on those as I've displayed those to you. It's impossible to think that he was drinking was not his usual red fruit punch. It's impossible to ignore the bittering agent we would submit to you that's in there. When asked why the prosecution didn't test for it, Sergeant Williams didn't have a good explanation, really. He relied on a Google search about it. They did test for fingerprints, none found. They did test for DNA. We've gone over that relative to this. They generated 5 profiles. What does that really mean? The search of Judy's house was totally unorganized and centered only on one thing. She did it. We don't really have to look for anything else. Let's go. And again, watching what took place with Trooper Williams when he comes back and he goes into the back bedroom, because Judy told him that Leroy was beforehand. He looks around, sees a couple of Fanta cans and decides, I'll take that one. That shows you exactly the effort that was being taken in this particular case. Each of these helps you determine that there is reasonable doubt in there. We saw photographs that were never collected or tested. Multiple Powerade bottles. How about we test more of those? Multiple orange Fanta cans. How about the can that went out to the NMS? Well, there was some sort of interference because there was some other substance. This is a chemical lab testing. There was some other chemical in there. We didn't know what it is. Well, you're a chemical lab. Why don't you test for that? Tell us what it is. Is that ethylene glycol? Is that cocaine? Is that something? What is that? Give us something. Nope. We decided not to finish the test, and the government said that we're not going to redo that test. Those are the items in the back bedroom. Is that where more of the 28 grams were coming from? What was in his bedroom at that point in time? We don't know. When she goes to the hospital, Judy's holding his hand. She brings him presents. She tries to stage a birthday party from him when he's in there. If Judy put AntiFreeze in the Powerade, why would you leave that in your house? She's a smart lady. You could tell by the interview with the police. So it's going to happen, and I'm just going to throw it into the trash. I'm just going to put it not only in the trash, I'm going to put it into recycling. There's no, in that context, ladies and gentlemen, again, it shows you the reasonable doubt, the circumstantial evidence that is an overreach in this case. Again, the RAIN Act turned out not even to be linked in this case. They found nothing incriminating in Judy's diaries and notebooks. How about the puppet about Barbara? How many people have done something like that over the years, right? What does that signify? And did we even have a year for that? Was that 2018? And that meant in 2022, 4 years later, she would want to murder Leroy? And the text message about being a Scorpio and knowing what to sting. It doesn't mention Leroy and has nothing to do with him. It seemed to be more directed towards Barbara. They didn't find what they were looking for, so they cut and paste together all these scraps of text messages, photographs, journal entries. It says, here, we think we've got it all together now. If she had something incriminating on her phone, why wouldn't she hide it? Wipe the phone. What did Tom Brady do? He took out the chip and he broke it. Why? How much do you have to know to be able to do something to hide it from on your phone? And again, Mr. Lemke, what he told you happened with him. Trooper Williams, young, smart, but eager to solve the case very quickly, very energetically, and without a lot of effort, right? We got it right here. But the investigation lacks merit in this particular case. Judy and Leroy's text messages, they're all positive in November of 2022. That's when this is happening, 2022. This is not something in September they decide he's going to murder him, but you know, I think I'll wait 2 months. The weather might be better in November to commit a murder than it might be in September. The text messages that are current showing the mental state and alert. Leroy's texting, again, I've told you that. What is there? Again, the video's somewhat difficult to watch, but she has seen him like this before, and she wanted to show him to Leroy, a big incentive to change. She doesn't delete them. Why wouldn't you delete them if you thought there was something wrong and you'd murdered him? Why would you not do that? That would have to be really something that would be on the pale as it would go, right?
Mr. Norkunis, you're out just about 50 minutes.
Thank you, Judge. This is a circumstantial case, ladies and gentlemen. When we began, our clerk, Ms. Draper, told you that Judy Church had placed herself before her country, which country you are. And you represent the best in our judicial system. I submit to you that the only true and just verdict in this case is that of not guilty of the charge here facing Judy Church. I want to thank you on behalf of Ms. Church, Attorney Scully, and Ms. Morrissey for your time, patience, and effort in this case, ladies and gentlemen. Thank you, Your Honor.
Thank you, Mr. Norkunis. Jurors, I'm going to suggest you stand up for just a moment. And in a moment, Mr. Camilio will address you. Sure.
All right, we're gonna vroom a little bit. What do you guys think about the closing arguments thus far?
All ready? Mr. Camellia?
Thank you, Your Honor. If you see those two cunts that live in the cottage, tell them I have words. You'll recognize those two cunts because you're with one. I guessed it all, didn't I? You're just here and dragged me along to buy gas because you don't want to be with me in Florida. Like that morning in Florida, you baited me with that cunt on the phone to say out loud that you don't want to be there. And when we left so abruptly, it's exactly what I said, that as soon as we got home, you'd leave. And you did just that, even though you promised otherwise. If you don't want to go back to Florida, just say so. If you and I are done, just say so. I'm not going to fork over another penny for you to fuck me over ever again. Because I know that you'll just still drag that skank bitch back with us. You keep complaining about the cold and that you want to go home. I want to be in Florida. You only want to be in Florida or anywhere else with my money. Obviously, I am not the one you want to be with because you fucked me over today too. I started the closing the same way I started the opening, with the words written by Judy Church. The first time in her notebooks and this time in the notes section of her phone. The Commonwealth can call witnesses, we can introduce evidence, we can talk about the science, but nobody can give you a better picture. Nothing can give you a better picture of the nature of the toxic and dysfunctional relationship that existed between Judy Church and Leroy Fowler than the own words that come out of the pen of Judy Church. She's the one that describes that relationship using those vile words, which I've used during the course of this trial because they're important. In a courtroom, we don't pretend that words don't mean what they mean. We don't say the C word. We use the words that people actually say. In the defense, they won't say it because they know how vile it is. They know how angry it makes Miss Church. They know how much she had to have hated Barbara Randall to use that word over and over and over again. She used it with her friends. She used it with Leroy. She used it with the police. The first time they show up at this house, at her house, not knowing a single thing about Leroy, not knowing a single thing about Judy Church, she says, oh yeah, she describes his other girlfriend as the cunt. This was not a healthy relationship. This relationship was toxic. Judy Church hated Barbara Randall. She hated that Leroy left her to go see Barbara. And it was a horrible thing, right? This is a horrible relationship. Leroy Fowler was doing horrible things, right? He treated Judy poorly. He treated Barb poorly. And Judy, she just hated it. He left her alone over and over and over again. Every time he left her to go to Barbara's house, what he was telling her, what he was saying to her was, you're not enough. You're not wanted. You're not loved. I need more than you can give me. Judy tried to make up for that with her money, right? She bought him she bought him 2 motorcycles. She bought him a second one because she saw Barbara Randall riding on the first one that she had purchased. That's how much she hated Barbara Randall. That's how much she hated their relationship. She bought him a truck. She bought him a house. And no matter how much money she spent, every single time, as I just read to you in Exhibit 46, no matter how much money she spent, she knew that Leroy was going back to Barbara. and she hated it. She snooped on Leroy's phone. She took pictures of their text messages. When the text messages were happy, when Barbara and Leroy are having a good time, it must have been awful for her. When they were fighting and breaking up, it must have made her happy, right? When she saw the video on Leroy's phone of him proposing to Barbara Randall, it must have been like a knife in the gut. God, she hated Barbara Randall. She hated her. She had the voodoo doll that, despite what Mr. Narkunis is not something that normal people do, that people normally do. It's just not. Leroy removed Judy's name, the tattoo that he had over his heart at Barbara Randall's urging. God, how painful did this have to be for Judy? No matter what she did, he always went back to Barbara every single time. She had to know, no matter what she did, he was never going to be faithful to her. He was never going to stay with her. Now, it was described during the trial by Mr. Scully as an open relationship. Judy herself told the police, he cheats on me. She knew this was what it was. She knew this was cheating. This was not an open relationship. This was toxic. This was horrible. It was dysfunctional. It was just horrible what he was doing to her. And she made the decision to poison him. Mr. Narkunis, there's no motive. There is motive all over this case. Not only is there motive, there's means and there's opportunity. Judy Church was the only person with Leroy Fowler the night that he died. Leroy was a perfect victim of ethylene glycol poisoning. His diet seems to have consisted entirely of soda, Powerade, cupcakes, and coffee milkshakes. Those were his 4 food groups. The man didn't eat anything or drink anything that wasn't pure sugar. The perfect vehicle for hiding ethylene glycol in the poison you're going to give somebody. Now, if Judy and Leroy's toxic and dysfunctional relationship provided the motive, that night is the means and the opportunity. You heard from Dr. Shin and you heard from the medical examiner how quickly the ethylene glycol starts to poison you since it gets into your body. The only person that was there that night with Leroy was Judy Church. Now, Leroy knew enough to not drink ethylene glycol on his own, right? Leroy worked on cars, he worked on motorcycles all his life. Leroy knew how dangerous this stuff was. And Leroy liked cocaine, right? That's what Leroy was looking to do. Leroy was looking for cocaine. And Leroy was doing whatever it is that Leroy wanted to do. Now, what's the first sign on November 11th that something is amiss? Now, I'm not talking about Leroy's illness. What I'm talking about is the 911 call. What does Judy say in the 911 call?
Yes, 108 Central Ave. We need an ambulance. Hear what's going on there? I don't know. My boyfriend must have ingested something.
My boyfriend must have ingested something. How did she know that he had ingested something? People only use the word ingest when they're talking about poison. No one says, I just ingested some water or I just ingested my morning cup of coffee. You ingest poison. And Judy used that word because, not because she was admitting that she committed the crime, but because that's what was on her mind. She knew full well that he had ingested something. Now, the EMTs show up and they don't know that he's ingested something. The first thing that they say to each other is, oh, maybe it's neurological, right? They take him to Anna Jakes. Anna Jakes doesn't know that he ingested something right away. They're still working. They're trying to figure out what happened to him. Doctors, nurses, nurse practitioners, they don't say, oh, yeah, he must have ingested something. No, only Judy Church says he must have ingested something, knowing full well that that's actually what happened. Before the EMTs get there, There's the videos. Those videos are horrible. They are chilling. They are the best possible evidence of murder in the first degree with extreme atrocity and cruelty. Usually you have to rely on a medical examiner or a doctor or a witness to say, oh, the victim was suffering. You don't have to rely on any witness. You don't have to rely on any person who came in and testified. You get to see for yourself how much pain, how much agony, how bad it was for Mr. Fowler that morning. He can't stand. He can't get up no matter how many times he tries. He can't talk. He can't breathe. He is moaning in agony. What does Judy Church say to him? Are you having fun?
You having fun?
If the person that someone loves is on the floor, unable to stand, unable to walk, unable to talk, you don't pull out your phone and you start videotaping. You call 911 for any of those things. You can't stand, you call 911. They can't talk, you call 911. They can't breathe, you call 911. Their stomach is like that, you call 911. He's got all of these things. And for a half an hour, she sits on that bed and she videotapes and she tells the police she gave him a pillow, she gave him a blanket. It's not on the floor, nothing. The only thing that's on the floor is the dog bed. She never mentions to the police that she took these videos. She never mentions to Anna Jake's hospital that she took these videos. If you wanted someone to get better, if you wanted to help somebody, wouldn't that be the first thing that someone would show the police or someone would show the hospital? Hey, take a, this is what he looked like. This is what he looked like for a half an hour. Maybe this will help you diagnose him. Maybe this will help you figure out what's wrong with him. In one of the more surreal moments of the trial yesterday, you heard Mr. Narkunis cross-examining the medical examiner. And he had the medical examiner agree that, yeah, if Mr. Fowler had gotten treatment sooner, maybe he could have lived. Who's the person responsible? Who is the person responsible for Mr. Fowler not getting immediate medical treatment? The defendant, Judy Church. She sat there in that house videotaping him for 30 minutes. She tells the police as early as 6:30 that morning, he started to fall down. She told the hospital as early as 3:30 that morning, he was falling down and that he couldn't stand up. Now, at some point, it had to become clear to her that explaining a dead body on the floor of her bedroom was not a good idea. She calls 911. She gets the chance to have her own narrative with the EMTs, with the police officers, with the firefighters that came. Oh yeah, perks. This is perks. I saw this before in 2019. There's no perks in his system. He never took any perks. She tells the police, oh, it's perks. There's no perks. There's none. They never find him. She tells them he had them. There's no evidence of that. Only her word. Even before November 11th, it appears Leroy was ingesting ethylene glycol. His symptoms, as described by Michael Hawkins, were the same symptoms that you heard about for stage 1 of ethylene glycol poisoning. You heard Dr. Shin from Mount Auburn talk about the kidney problems, the kidney failure that it looked like Leroy was experiencing, and how that could have been, how concerned she actually was for someone who's not even with us anymore about the fact that he couldn't urinate. One of the most serious symptoms that she could tell you about kidney failure. Judy talked openly to everybody about poisoning Leroy Fowler. Now she says it's a joke. As Tammy Fowler said when she was on the stand, it's not so funny after Leroy is poisoned. She texted people about poisoning. She texted, I want to poison somebody, and I have somebody picked out. This was in September of 2022, weeks before Leroy died of ethylene glycol poisoning. She told the police how they used to watch true crime. She called them the murder shows. Perhaps in answer to Mr. Narkunis' questions, that's where she learned what ethylene glycol could do. In that first interview with the police, when did she show the most emotion? Not when talking about Leroy's condition, but when they mistake her for the other girlfriend, for the visiting girlfriend. She says, I'm not the visiting girlfriend. Two months before his death, she took a picture of his room. And it was that exhibit that we talked about a couple days ago, the orange liquid in the cup. See it on the screen. The defense insisted, no, it's red, it's red, it's red. Well, Sergeant Williams insisted, no, it's orange. And you can see it's orange. And it's exactly the same color as the liquid in the Powerade bottle. Why would anyone take that picture? Why would you ever take a picture of that on your phone of what somebody's drinking? Is it another trophy? Like the videos that she took of Leroy as he lay dying on her floor? We don't know, but what we do know is that that orange is the exact same color as the orange in the Powerade bottle. That picture taken in August of 2022. What else? The murder weapon, the Powerade bottle. It was found in her kitchen. It has her DNA on the mouth of the bottle underneath the cap. That's not transfer. That did not sit in that recycling bin and pick up DNA underneath that cap. You heard Ms. Hooper tell you, she swabbed the mouth and she swabbed the underside of that cap. It was not picking up DNA from anywhere. No matter, Mr. Lakin can tell you about transfer all he wants. But DNA really, it really does come from touching things and drinking from things. Her DNA is on the mouth of that bottle. She drank from that bottle. She drank, did she finish the Powerade? Did she show it to Leroy so that he would think it was safe, take a little sip? She tells the police actually that night when Leroy came to her bedroom, she thought he was dehydrated. She showed, yeah, I gave him something to drink. Now the defense rests much of their case, much of their defense on the bittering agent that they say would have kept Leroy from drinking this because he would have noticed it. Now, you heard from NMS, they don't have this test. State Police Crime Lab doesn't have this test. Now, and the defense says, well, the state police, Trooper Williams, should have gotten this test done. Can you imagine the uproar from the defendant if the Commonwealth of Massachusetts had called up a random marijuana testing company with no forensic abilities at all to do a test in this case? Can you imagine the outcry? Mass State Police call weed company testers to test evidence in a murder case. Now, these are the same people, when you heard the testimony yesterday, that provided their results to a different defense expert 2 months before they actually did the tests. I think the less said about MCR labs, the better. Those bittering agents exist to keep people from drinking straight AntiFreeze. They don't exist to keep people from drinking AntiFreeze that has been mixed in with soda or Powerade, that it's down to 2.5% of the bottle. That's not what it's there for. You're not going to take that. You're down to 1 or 2 parts per million at that point. Regardless of the Bitrex that was in that Powerade, one of the uncontrovertible facts of this case is that Leroy Fowler had ethylene glycol in his blood. He had it in his body. He had it in his system. That's what he died from. Dr. Shin agrees. The medical examiner agrees. And if you look at the Beth Israel records, you'll see that that's what he died from as well, despite the representations made in the closing by Mr. Narkumis. Right at the top of the Mount Auburn records, it's right at the top of the differential diagnosis, is ethylene glycol poisoning. And that was before they even had the 52 milligrams per deciliter number of ethylene glycol in Mr. Fowler's blood. Leroy drank ethylene glycol within hours of that video being taken on November 11th. He had to have drunk it in the house. He had to have drank it that night. Judy Church had complete and utter access to his food and his drinks. In her interview, you heard her say, "You won't find Leroy's fingerprints on a pot or a pan." She did his cooking. She made him his drinks. She made him his milkshakes. He was the perfect victim. He had COVID and lost his sense of taste. He destroyed his taste buds with years of cocaine use and cigarettes. He was the perfect victim for an ethylene glycol poisoning murder. That is motive means an opportunity. Leroy didn't kill himself. If he had, the bottle of AntiFreeze would have been sitting in his bedroom, right? Someone shoots themselves, the gun falls to the ground. It's there underneath the body. Someone takes pills, you take a whole bottle of pills, the pill bottle is there. There's no antifreeze there. If he had been drinking that himself, just drink it, kill himself. No, there's absolutely no evidence of that. As Judy Church told the police numerous times, oh, Leroy thought far too highly of himself to kill himself. Not a single person came in here and gave a shred of evidence that suggested that Leroy Fowler was going to kill himself. Leroy Fowler liked his life. He liked having Judy buy him things. He liked being able to go to Barbara when he wanted to. He wasn't the one with the problem in this relationship. Judy was. Now, a few minutes, well, that's actually been a long time now. Almost an hour and a half ago, the judge explained to you the elements of first-degree murder, the two theories that the Commonwealth is proceeding under: premeditation and extreme atrocity and cruelty. Now, with respect to premeditation, there are a few things in the world when you're going to kill somebody that require more premeditation than taking a poison and adding it to someone's drink. The very definition of having to think about what you're doing, unscrewing the cap, pouring it in, making sure that they drink it. And as for the extreme atrocity and cruelty, that video provides all the evidence that anyone would ever need to know that this murder was committed with extreme atrocity and cruelty. Leroy Fowler was not always a good man, but he did not deserve to die the slow, horrible, painful death that Judy Church inflicted on him. All that she had to do was leave. All that she had to do really was kick him out. He didn't have a house. He didn't have any money. It all came from her. But she couldn't do that, right? Because she couldn't let go of this competition that she had with Barbara. One of the notes that I read to you yesterday said, "You'll lose this competition every single time. You will never," and I'm paraphrasing, "you'll never defeat me. You'll never beat me." That's what caused this. That's what brought along what happened on November 11th. That's what caused the poisoning of Leroy Fowler. I ask you that after your deliberations, you return a verdict of guilty on both theories of first-degree murder and find her guilty. Thank you.
Thank you, Mr. Camellia. Now, jurors, we're going to get back to the instructions. The first part was about 20 pages long. The second part's about 20 pages long as well. We'll probably push a little bit past the 1 o'clock hour, but I would like to get these, if everyone's good to, everybody still good to go? All right, we will finish these instructions and then, okay. We will take a very quick break and then we will finish the instructions. That's fine.
All right.
We'll be in very brief recess.
Call stand a brief recess.
All right, we are caught up to live time. We don't have any more room. So for just a few minutes, we'll go back over to the Georgia versus Suzanne Miracle, and then we will come right back to this as soon as they come back into the courtroom.
You made and undertook an investigation to try to find out exactly how far away, as best you could, the barrel of her gun was at the time the shot was fired.
Yes, a general.
And again, I know you're not telling these folks it was 6 inches. You're saying that's the range. That's where I think it was.
Right.
It could be further than 6 inches, could be shorter.
Yes.
Okay. But 6 inches is your guess, your best guess.
Yes.
What you did was you went to your lab, which I'm calling it your lab, but you did this outside.
Yes.
You fired some test shots from 2 different ranges.
Yes.
One of them was from 3 inches away and one of them was from 6 inches.
Correct.
And you'd agree with me, you never did a test fire beyond 6 inches.
No, not with this.
May I approach the witness, Judge?
Yes.
What number are we on? D3? Thank you. Showing you defendants 3.
Yes, sir.
You recognize that?
Yes.
Can you tell the jury what it is basically?
This is a photograph of the test shots. You can see the 6-inch labeling down at the bottom. It's been fired into a door panel as well.
Gotcha. Does it fairly and accurately represent the photo you took of the 6-inch test fire in this case?
Yes.
Tendering defendants 3? Hand that to you.
No objection.
Admitted.
Defendants 3. May I publish, Judge?
Yes.
There's 2 things that come out before I publish this. There's 2 things besides the bullet, besides the projectile, there's 2 things that are coming out the front of the barrel when you fire a shot from a gun like.
All right, they are back in. We're going to get you guys over there and back into court.
All right for the jurors. Be seated.
Jurors, for those who are reading along, I am now on page 20 of the instructions, part 2 after closing arguments. Jurors, you have the most important role in this trial because you alone must decide who and what to believe and whether the Commonwealth has proved Ms. Church's guilt beyond a reasonable doubt as to the charge before you. You must be completely fair and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. As I told you earlier, you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, and the things that were marked as exhibits and any stipulations of the parties. Again, a stipulation is an agreement between the parties that the recited facts are true and should be accepted as true by you without the need for any supporting evidence having been presented. You will have all the exhibits with you in the jury room. There are other things that are not evidence, and you may not consider them when deciding this case. They include the following. The fact that Ms. Church has been indicted or charged in this case is not evidence. Questions that a lawyer asked of a witness are not evidence. Only the answers are evidence. For example, if a lawyer asked, "Wasn't it raining outside?" and the witness answered no, or said, "Well, it was cloudy," the question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection, and therefore the witness did not answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part of or all of an answer by a witness, then that part of the testimony is not evidence and you may not consider it. Anything that you may have seen or heard when the court was not in session is not evidence. Any notes that you have taken are not evidence, but you may use your notes to refresh your memory of the evidence. As for the opening statements and the closing arguments, while you may consider them in assessing the evidence you have heard and in deciding what facts to find and conclusions to reach, I remind you that they are not themselves evidence. Your role in this case is the most important one because you and you alone will determine what the facts are. In a sense, you are judges when you do that. You are the sole judges of the facts. It does not matter what I or the lawyers think the facts are. All that matters is what you find the facts to be. Consequently, you should draw no inferences, favorable or unfavorable, to either side because of anything that I, as the judge, may have said or done during the trial of this case. If you think that during the course of the trial I made certain rulings that suggested how I felt the case was going, or how any issue of fact should be resolved, or how you should find the facts, then you are to ignore such belief because I did not intend to do so. I have no view of the facts of this case. Again, it is you and you alone who must decide the facts of this case, and you must do so free from interference from anyone, me included. You alone will determine the weight and the effect and the value of the evidence and the credibility, that is the believability of the witnesses. Once you make those determinations of fact, it is then your duty to apply those facts to the law as I now give it to you. In deciding what the facts are, you all have certain tools available to you. The primary ones are your own common sense, good judgment, and general life experiences. Evidence can come in different forms. The primary ones are testimony by witnesses about what they saw, heard, did, or experienced, and tangible items such as documents or photographs that were marked as exhibits. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that is direct evidence that it was raining. Some evidence proves a fact indirectly. That is also what is known as circumstantial evidence. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off an umbrella. That is indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove that something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some information that we know, we apply our intelligence and common sense, and then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. The Commonwealth may be able to prove a criminal charge with direct evidence, indirect evidence, or a combination of both. A very important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it, or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or was deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. You may also decide, or not, that such a lie causes you to disbelieve other testimony by the witness. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something, but actually be mistaken. For example, a witness might not have paid close attention or might have misunderstood what was happening, or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of the person's testimony was not accurate, then you should not consider the inaccurate testimony. You may also decide, or not, that such mistaken or inaccurate testimony causes you to disbelieve other testimony by the witness. How do you decide whether you believe particular statements by a witness? Ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Does the witness's memory seem accurate? Was the witness's testimony consistent with other evidence or instead contradicted by other evidence? How did the witness behave and answer questions? Did the witness have any motive for testifying in a certain way or have any other bias that may have influenced the witness's testimony? In assessing the credibility of a witness, you may consider whether, prior to the trial, the witness made any statement that was inconsistent in some way with the testimony the witness gave on the witness stand. That is, the prior statement differed from or contradicted the witness's testimony here in court. That is what is known as a prior inconsistent statement. Unless the prior statement either was adopted as true by the witness on the witness stand, or it was made under oath, such as before a grand jury, the prior statement is admitted into evidence solely for your consideration in evaluating the witness's credibility or believability. If you determine that a witness made such a prior inconsistent statement, it is for you to decide to what extent, if at all, the credibility of the witness is adversely affected by it. But you may not consider the earlier statement as evidence or proof of the truth of any fact contained in the earlier statement. Again, unless the witness either adopted the prior statement as true or the prior statement was made under oath. During trial, you also heard one or more witnesses testify to making some statement at an earlier time that you might find was consistent with or similar to some aspect of the person's trial testimony. That is what is known as a prior consistent statement. Normally, under our rules of evidence, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. That rule rests in part on our common experience that saying something repeatedly does not necessarily make it any more or less true. But we make an exception to that rule where there has been a suggestion that a witness may have recently contrived their testimony. In determining how reliable a witness is who has been accused of recently inventing their testimony, you may consider any earlier statements that the witness made which are consistent with the person's present testimony. It is for you to say how important the consistency is, depending on when any earlier statement was made and any other circumstances that you consider significant. The earlier statement is not itself positive evidence of any fact that is mentioned in it. To repeat, if there has been a suggestion that a witness recently contrived their testimony at this trial, or some portion of it, then you evaluating that claim, you may also take into account any earlier statement the witness made which is consistent with their trial testimony. The prior statement is relevant only as to the witness's credibility, and you may not take it as proof of any fact contained in it. You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way you would evaluate anyone's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer or works in some law enforcement capacity. I want to repeat an instruction I gave twice during the course of the trial with respect to statements that were attributed to the deceased, Mr. Fowler. One was a statement that Tammy Carbone testified she heard the defendant, Ms. Church, make, in which the defendant purportedly related a statement that Mr. Fowler had made to her. A different witness, Michael Hawkins, testified about the other statement, which he related that Mr. Fowler made to him directly. I want to emphasize to you once again, as I did in my earlier instructions, that it is entirely up to you to decide whether and to what extent you credit any testimony regarding purported statements by Mr. Fowler. And it is for you alone to determine, based on such assessment, whether Mr. Fowler made either statement. But if you do find that Mr. Fowler made either or both of the statements in question, you must bear in mind that those statements were admitted for a limited purpose, and you must confine your consideration of the statements to that specific purpose. The statements were admitted as evidence of Mr. Fowler's state of mind prior to his death. You may consider Mr. Fowler's state of mind in assessing whether or not he ingested ethylene glycol knowingly and intentionally. But you may not consider either statement for the truth of Mr. Fowler's stated belief regarding the defendant, Ms. Church, or her conduct or intentions. That would be an impermissible and forbidden use of that evidence, and it would be unfair to Ms. Church. Most of the testimony during the trial came from witnesses who saw or heard something. Several witnesses, however, such as the medical examiner, told you about opinions or conclusions they reached based on some special training or experience. We often refer to such testimony as expert testimony. But even if a witness has some special training or experience, that does not necessarily make the witness's testimony any more believable or important than other testimony or exhibits. You must decide whether you believe an expert witness and how much importance to give to the witness's testimony. You should consider all the factors I have previously mentioned, including whether the witness had a motive to testify in a certain way or some other bias that could have influenced the witness's testimony. In addition, as you evaluate an expert witness's opinions or conclusions, you should also ask, was the witness's testimony supported by the facts of this case, as you find those facts to be? Did the witness use guesswork or assumptions that you do not find to be convincing or are not consistent with the facts, as you have found the facts? Did the witness have sufficient education or experience? You may decide to accept all, some, or none of the opinions or conclusions offered by a witness. But please remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you to decide this case and to decide whether you accept or reject any opinion or conclusion that a witness offered during the trial. You may have taken notes during the trial. Your notes may help you remember the evidence, especially the testimony, but of course they are not an actual transcript or official record of what was said. So use your notes only to help you remember what you heard and saw during the trial. Whether you took notes or not, you must rely on your own memory of what the witnesses told you. After the trial is over and you have returned your verdict, a court officer will collect your notes and destroy them. It is also up to you to decide how important each part of the evidence is, whether it is testimony by a witness, an exhibit, or a stipulation. Whether evidence is direct or indirect, you should give every piece of evidence whatever significance you think it deserves. You are not required to believe something simply because it appears in an exhibit. It is up to you to decide how important any exhibit is. You do not have to treat testimony by the witnesses as more or less significant than the exhibits. You may find that a witness's testimony is very important or that an exhibit is more important. That is up to you. I want to address another important issue that I discussed with you in my earlier instructions, fairness considerations. I will be repeating and expanding upon what I said then because this issue is so important. Each of you has taken an oath and promised to be fair. I am sure that you want to be fair, but that is not always easy. Part of being fair is being willing to examine your decision-making process to be sure you base your decision as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them. We all have them simply because we are human. They affect our actions and decisions without us even realizing it. You may have heard this called implicit or unconscious bias, and that is what I am talking about. We judges have the same problem as everyone else, so let me share a few strategies that we have found useful. These strategies will help you make sure you decide this case based only on a careful examination of the evidence and on the legal rules I've explained to you. First, slow down. Do not rush to a decision. Take time to consider all the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we may not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were in different social or economic groups, or had different occupations, or had different ages, genders, gender identities, or sexual orientations, or came from different racial or ethnic backgrounds? Fourth, listen to one another. Other jurors may have different points of view. If so, they may help you make sure you are focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions, so don't hesitate to share your views. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you think is important. When you explain your thoughts to other jurors, you help everyone focus on the evidence. If you do these things, then you will do your part to reach a decision that is as fair as humanly possible. That is your responsibility as jurors. I'm now going to give you some instructions about how to conduct your deliberations. First of all, you must keep your deliberations secret. You should not tell anyone outside the jury room, not even me, anything about them. For example, please do not tell me or anyone else the results of any votes you may have taken before you all agree on your verdict. You must not tell anyone how your discussions are going or what any jurors said. If you need to communicate with me before you reach your verdict, you should send me a written note in a form you all agree on. It must be signed by your foreperson. I will discuss your note with the lawyers. Then I will either send you a response in writing or bring you into the courtroom and respond to you in person. If you do send me a note, it should not mention any votes you may have taken or anything else about your deliberations. Do not talk about the case unless all of you are present and no one else is in the room. If one of you needs to leave for a moment, the rest of you should stop deliberating until that juror returns. If we break for the day before you reach your verdict, you must not communicate with other jurors about the case until the next court day and only after we gather in the courtroom and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with an electronic device such as a cell phone or tablet. This also applies to the alternate jurors. You will be provided with a verdict form on which you will record your verdict, whatever it may be. There are several options on the verdict form in accordance with my instructions. The options are not guilty, guilty of first-degree murder on a theory of deliberate premeditation, guilty of first-degree murder on a theory of extreme atrocity or cruelty, and guilty of second-degree murder. Your foreperson will sign the completed verdict form and present it in open court when asked to do so. The law permits only 12 jurors to participate in deciding a criminal case. We started with 16 jurors. We chose 16 of you originally in case one or more of you got sick or had some other unexpected emergency. In a few minutes, our clerk will randomly select 4 of you to serve as our alternate jurors. The other 12 of you will work together to decide this case. If you are chosen as an alternate juror, your continuing service is still very important, and you must comply with all the rules I've given you. The alternate jurors will stay in another room from the deliberating jurors, and they must not discuss the case with anyone else or with each other. If we were to lose a deliberating juror because of some personal emergency or sickness, a replacement juror would be randomly selected from the 4 alternates and sent into the jury room. If there was need to exercise a second deliberating juror, we would randomly select one of the remaining 3 alternates and send that juror into the jury room. By the way, anytime that we do have a need to replace a deliberating juror with an alternate, the newly constituted jury is required to restart all its discussions from the beginning. One of you will serve as foreperson of the jury. The first order of business of the 12 deliberating jurors will be to select one among you to serve in that role. The foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinions of all other jurors. As I've already stated, once you agree on your verdict, the foreperson will fill out the form and will report your verdict in court. When you work together as a jury, you will be making a decision as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach your verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You have all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. So you are all equally qualified to reach your verdict. I have a few suggestions that might help you as you work together. First, you should discuss and analyze the evidence before you take any vote about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, as I said before, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as the other jurors talk about the evidence that they found important, please listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your thinking. Fourth, don't be shy. As in any other group, some of you will be more comfortable than others in sharing your thoughts. But you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one who remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it is the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, you each must decide this case for yourself. I'm going to see counsel for just a moment at sidebar, and then I will be right back with you to conclude my remarks and select. Alternate. It is now time for our clerk, Ms. Draper, to randomly select 4 of you to serve as our alternate jurors.
Juror in seat 4, juror in seat 6, juror in seat 13, and juror in seat 15. Then that's 4, 6, 13, 15. You've been selected as alternates. You may remain seated for right.
Would those jurors just raise their hand for a moment? You remain in place, but I just want, we've got 3. Do we have 4 hands up? There we go. Okay.
Mr. Leno,
Okay.
you're also an alternate.
To those alternates, let me just say before I proceed, I know it feels like you just got voted off the island, but you saw that it's a completely random process. But I also just want to emphasize what I told you in my formal instructions, which is your continuing service remains very important to us. Sometimes alternates get pressed into service during deliberations. And so we are very grateful for your continuing participation, and I want to thank you for that right now. In a few minutes, the deliberating jurors will go and start their private discussions. To those 12 jurors, I now say, have confidence in what you are about to do. By serving on this jury, you carry on a long and proud tradition of citizens serving in jury trials in Massachusetts. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict. Now, jurors, the attorneys and Ms. Draper are going to work to get all of the exhibits in order. They'll be coming down to the jury room imminently. You've got your lunch waiting for you, I presume. We do. And the alternates will have their lunch separate from the deliberating jurors. A laptop will be provided to you. This is a pristine laptop for playing of any electronic media, so you decide what to play, but you can view all the exhibits, including the electronic ones, as much as you wish, and you can use that device for the electronic media. So with that, we will have our court officer sworn.
Yes, Your Honor. Do each of you solemnly swear that you will keep this jury in some convenient place until they are agreed, that you will not suffer any person to speak to them, nor speak to them yourself unless by order of the court, or to ask them if they have agreed? And when they have agreed, you shall return them into court unless the court shall otherwise order, so help you God. Thank
And
you.
with that, I'm going to excuse our 12 deliberating jurors to have lunch and commence their deliberations, and our
All
four
right.
alternates to commence their patient waiting.
Judge, you can bring your books with you, man.
Everything may go with you.
Oh, sorry.
No, everybody's going to go with the court officer. They'll direct you where to go.
Are you taking a lunch break before we get the exhibits together? Ms. Draper?
Excuse me?
The exhibits, are you doing that now or after the lunch break?
Yeah, I was gonna go with you.
I'd leave
I'll get the
it to
exhibits.
your
You're gonna get the
I'll
exhibits?
discuss it with
Judge.
counsel, Your Honor. I mean, they
All right.
will be having their lunch
Yep.
break now.
Just one thing, yesterday I referred during the testimony of, I forget his name actually, the gentleman from MCR Labs, to that, the wearing report that I used
Yes.
in the cross-examination. I thought we should perhaps mark that
For
for
identification?
identification.
That's fine.
No
Hap-
objection.
Happy to do that.
Your Honor, for the record, I did mark the court's instructions to the jury a copy as Q, so this will be R.
This will be R.
This is
Okay.
correct.
R for identification
Yes.
is Ms. Waring's report. All right.
Just so the record's clear, Attorney Scully and I discussed the medical records, and there's no redactions that either party is requiring.
Very good. Excellent. All right. Well, I'm about to recess, but I want to thank all counsel for their efforts in this case. It's clear to me that both the Commonwealth and Ms. Church were very ably represented in this trial. And beyond that, it's really a pleasure for me dealing with each and every one of you. I have no idea how this case will come out, but at this juncture, I wanted to express my gratitude to all of you for your efforts in this case. We'll be in recess.
Court, all rise.
We can do this now. It's fine. Yeah, sure.
All right. And with that, we are in verdict watch for Massachusetts versus Judy Church. I will have it up on the screen just in case we get notified that there is a verdict today. We will now move over. We've had a couple of requests for the Kelsey Fitzsimmons verdict. I guess a few of you guys may have missed it. I am happy to play it so you guys can see it. Let me get it shared. It's going to be blurry just for a minute until the judge comes into view.
Good afternoon. We're on record on the Kelsey Fitzsimmons matter, docket 2025-77 CR 311. All counsel and the defendant are present.
Thank you. So before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this, this is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And so as the lawyers know, unlike when a judge presides over a jury waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Newman, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard to perform their solemn jobs fairly with the utmost civility, and professionalism. They serve as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Newman, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Newman and his fellow officers doing the best they could under tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I had considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following 3 things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Newman. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proves each of these 3 elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Newman for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding custody of Katie. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, strike that, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan. And my verdict is, and must be, not guilty. With that, I will hand the signed verdict slip. I will hand the signed verdict slip to Mr. Wayne and ask that he advise Ms. Fitzsimmons of her statutory rights.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders that you be discharged of this indictment and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you.
Thank you. Court is in recess. Good, all right.
Please exit quietly, and thank you once again. Thank all. If there are other sessions still going, please be quiet on your way out.
I'm going to leave it here just so you guys can see how full that gallery is. All of the emotion that was coming forth in the gallery. Again, the verdict the judge read was not guilty. We wish her the very best. I hope that she makes progress moving forward. She's still got a lot a lot of stuff that she's, I'm sure, got to work through. And again, we just wish her the best. I'm going to leave it here so you guys can see, and then I will move it on over to the Georgia versus Suzanne Miracle for the replay of day 2.
Say that again, Jay. Code 1 is also still. Everybody should be tripling out. Some of you guys want to start going down so that we can get people moving.
All right, I'm going to get us started, and here we go.
2 types of substances. Let me help you with that.
You're going to have the projectile that's going to come forth, and you're also going to have the residue, the stippling that we talked about yesterday, powder residue and stippling, yes.
So it's powder residue, which is, it's unburned material that comes out along with the bullet.
The stippling
burn. The stippling's burning.
Stippling powder is, well, I mean, it's burning as well. You get the powder residue, but you have the stippling that will impact and stay where the powder does not.
Gotcha. Would you agree with the characterization that it's 2 different substances, or is it the same substance? One of them burns and leaves a stippling burning into the material, and the other one's just powder?
I would say it's just powder where the stippling is.
Is it the same substance? It's just one's burning and one's not, or they're both burning?
One is fired, I mean, it's burned.
Okay.
The stippling is more particles that have still remain intact, where the powder is disintegrated, I guess you could say.
It's powder is a good word. That's why we use the word powder. Let me show you Defendant's Exhibit 3. When we look at Defendant's 3, I'm looking for that pointer, I'm sorry. It's right there. Where you've notated, can you all hear me? Where you've notated 6 with the open
6-inch mark, yes.
The dashes that we commonly call inches. That's just your notation. This is a 6-inch away shot that you made.
Right.
And what we see here is, in addition to the stippling that you testified about yesterday, is powder.
Correct.
And it's even in like a little fan. It kind of fans out because the bullet comes out.
It's twisting. It's turning in a.
It's twisting just like the projectile. And so we get this powder that, if you're close enough, you're going to have powder in addition to stippling.
Yes.
And this is a dark surface because you were trying to recreate the door here.
Right.
the door here is a black door.
Dark, black, yes.
A dark, yeah, I'll call it black.
Charcoal black, yes.
Okay. And the paint that you used on your test door is the same, as close as you can get?
It's close.
Okay. And it left this white twisty powder all over the outside of the door, all over the outside.
Around the test fire area, yes.
And when you came and took photos of the scene of 4238, States 59 has already been published. Is that public? It's already been tendered, is that published?
Yes.
Do it like that. The photos from the scene from that night, these are taken that night.
Yes.
That door, you would agree, does not have any of that powder that twists and would indicate the powder flew out and stuck to the door.
Correct.
Now, and
I'm sorry.
go ahead.
What you're looking at, the stippling, the reason we're looking at the stippling instead of the powder burn is the powder is not going to impact and stay on the door. The stippling is actually going to impact, this is what you're seeing around the entrance there, the little pricks, the little impact points.
Mm-hmm.
Those we're looking at because they'll stay. Powder is, like we discussed, is powder. It's going to fall off, it's going to dissipate. And even with the impacts to the door, I would imagine that you could easily hit it and wipe away the powder versus where the stippling is going to stay in place.
In other words, you believe the reason we don't see any of this powder is because this door was struck with a hammer in these other places.
It was struck and it was also pushed in, but the photographs with the powder that are around the demonstration that we did, those were taken within just a few minutes, where the photos were taken here after time had elapsed. So, I mean.
Sure, time had elapsed, but this is powder that was fired at this door on this night.
Yes.
And you weren't there, the next day and taking these pictures. This is the night of.
The morning of or after, yeah, it's early morning, so it's a few hours, but yes.
And you know what time it was you got on scene? Can you check?
The warrant was signed, or we were informed at 3:45 in the morning. Originally, I responded before I went to the ER, but the time that the search warrant was signed, we went into the house at 3:45.
3:45 a.m. If the shooting happened at between 1:06 and 1:10 a.m., that's about, what, 3 hours?
3 hours or so.
That sort of leads me into my next area that I want to talk to you about, okay? When you are doing your work as a crime scene investigator, the integrity of the crime scene is very important to you.
Yes.
You want to make sure that it hasn't been tampered with.
Yes.
You want to make sure it hasn't been contaminated.
Correct.
You wouldn't want, if you had all the power in the world, which I know you don't, right? But you wouldn't want people traipsing in and out of the crime scene. True?
True.
The goal is to have this crime scene be as pure as you can possibly get.
Correct.
And what's going on in that room where the shooting took place before you get there is important to you.
Yes.
And who's been in there and what they've been doing, you'd want to know that.
Right.
And you knew by the time you got to the crime scene on March the 8th at 3:45, I got that right?
Second time, yes.
Second time. Well, even, I guess let's go to the first time. Even by the time you got there the first time, which you said was what time?
It was earlier than that. Let's see. I believe it was around 2 when I got to, or just after 2 when I got to the hospital. When I drove by there, I just drove by and realized we didn't have the search warrant yet, so I went to the hospital instead. So.
And at this point, as you know, if you're going to the hospital, Mr. Barron's body's already been taken out of there.
Correct.
And showing you State's Exhibit 49 that was previously offered, published.
Yes.
What you knew is that at least 3 or 4 folks from fire EMS had been up into that room in addition to the 2 deputies that had already been in there.
Correct.
They had opened up this patient transporter by Curaplex, right?
Right.
The instructions apparently got left behind and somehow a bullet got on top of it, or a bullet got on top of the instructions.
Yes.
And just looking at what this thing is, this patient transporter, it appears to be some sort of a supporting bottom to it and some sort of a vinyl maybe cover to set the body on.
Right.
Did you undertake to watch the body camera of the police officers who were close enough to see Mr. Barron's body being carried out of the room and down the stairs and out?
I didn't see the full body cam where they were carrying or working on him or carrying him down, no.
Are you aware that there is body camera of him being carried out of that room and down the stairs?
Yes.
Okay. Do you disagree that on that body camera, there's again about 4 EMS folks, they've got him on this contraption and they're just walking him right down those stairs, those 2 landings of stairs and on their way out?
I'm going to object to that because Sergeant Durham hasn't seen the body cam.
And I'd be happy to show it to him.
I apologize. I'm a little confused. I thought he said he was aware.
He did say he was aware.
I mean, I'm aware. I didn't see the full body cam. I didn't see the people taking them out. I'm aware as a crime scene person, when you get to the scene, you're going to have officers clearing the scene. You're going to have fire and EMS that are there working them. So I'm aware that they're there and they're doing that. I believe I even mentioned there's a blood smear on the wall that was more consistent with them carrying the body out as leaving the smear as to any kind of really relevant.
Fair point. All right. Without commenting on the evidence, I mean, if he knows, great. If not, I mean, it sounds like standard operating procedure. So as of the state's objection, that's sustained, but you can go about another way.
2 seconds, Judge. Just work. Gotta find that body camera video. It's, there are spots of blood on the stairs. And I'm going to show you. States 29 and 30. Approach witness, Jeff?
Yes.
He's been previously admitted.
Yes.
Yep. May I publish these, Judge?
Yes.
Showing you 30. What we can see here on 30 is spots here, here, there.
Blood drops, yes, sir.
Blood drops. And these are the type of blood drops you talked about before. They're passive, right?
More of a passive, yes, a straight down drop.
They're straight down drops, and we know they're straight down drops because they're circular.
Correct.
They don't have a tail on them one way or another.
Right.
Okay. And these are consistent with, well, of course, first of all, this is the path that Mr. Barron's body was carried out, landing to landing and out of the home.
Yes.
And it's not an enclosed, he wasn't placed in a body bag. He wasn't encased by something.
No, they are, from my understanding, EMS worked him at the scene, so he's being treated.
He's being treated. And your understanding was he still had some sort of a discernible pulse when they got there. Did you know that?
No, I mean, they're working him, so I'm assuming.
Okay. In other words, they didn't arrive and go, okay, he's deceased, we can't.
They didn't just leave him. They did take the body and take him in for treatment. So I'm not sure what they had at the time, indications or whatever.
And you wouldn't disagree with me to say the source of these is likely the body being carried out down the stairs.
No, I'm not going to disagree with it. I mean, it's very probable it was.
When we look at states 45, the public judge has been admitted.
Yes.
In states 45, we can see, here's the little instructions for the carrying item, right?
Correct.
We've got that towel.
Correct.
And there's even blood over here.
Yes.
And we know his body originally was in this position by the time the deputies came in.
Right.
We didn't get to watch how EMS and fire got him onto this contraption and how they got him out of that room. So we just don't know that.
Correct.
We don't know if they had to, he weighed 235 pounds. You're aware of that, right?
No.
You weren't aware of that?
But
I
saw the body, so yes, that's.
You don't disagree with 235?
No.
6'3", you don't disagree with that?
No.
Okay. And I know you didn't measure him or anything like that, but so he's in this position originally. Somehow he's turned to get out of there, and several individuals, as far as we understand, load him up and get down the stairs.
Correct.
And we don't know if they loaded him on and spun him initially. Correct?
No, I don't.
You wouldn't know because you didn't see it.
No.
Right. And that's, I'm not putting that on you. I want these folks to know what we know and what we don't. Okay? This bag here was another one of the items that was in the crime scene.
Correct.
And you did inspect that bag and
The case, yes, it was collected.
this item here also has blood on it.
The towel?
The bag.
Yes.
The bag had blood, on the bottom of it, on the sides, all that stuff,
Yes.
right?
Well, yes, I had it on the drips that were coming down on the top of it.
Drips on top of the bag as well.
Yes.
That passive sort of drip that you sort of identified over here,
Right.
meaning drop down.
Yes.
Okay. I want to talk to you about this holster that we see in 45 in the corner here.
Okay.
Okay. You testified about the holster earlier, so I want to make sure that we're all on the same sheet of music about what you found and what it means. Okay.
Okay.
The holster itself, when you look at it with the naked eye, you can kind of see some blood, but it's not like screaming at you. Is that accurate?
Yes, there's some smearing, it looks like, on a couple of places that you can see, but then you've got darker areas that it's harder to see. So
It's sort of like, this door, on the back of this door at the bottom, you can see that that's blood. It's
yes.
pretty obvious, right? You didn't have a question about that from the start.
No, it's.
And the floor.
Right.
And also, even that bag, right? The bag itself.
Correct. It's.
Naked eye versus using a tool, they're two different things.
Correct.
And what you noticed after you put the reagent onto the holster is somebody with a bloody hand picked up that holster and probably unclipped it.
Yes.
That's a fair conclusion, right?
Yes.
And we think, obviously, that it happened within this room.
That's fair. Yes.
Fair guess, right?
Yes.
And what we notice when we look at the bare foot prints here in this area is it seems like, let me see if I can get a better picture for you. Let's go with states 43. That goes?
Yes.
Take a look at states 43 at the top. It's like left foot, right foot. You see that?
Yes.
It's like left foot, right up to the edge of the bed there.
Correct.
Right? With bare feet.
Yes.
And then turning.
Yes.
And heading back over to the place where Mr. Barron's body is.
Right. Yes.
That would be consistent with someone with bare feet walking over to the bed, picking up the holster, unclipping it, taking out the gun, and walking back over to where Mr. Barron was.
Yes.
Bless you. One of the things that you were investigating, in addition to blood stuff and holster, was with respect to the Beretta pistol that you think fired 3 different shots.
Yes.
And one of the questions you had was, okay, I've got blood all over this Beretta. I can see that. Anybody can see that, right? Everybody knew that.
Right.
The question was, hey, did somebody take this thing and actually load it, right? Did they put the magazine in after they had blood on their hands and all that? That was a question.
Question, yeah, it's not necessarily loaded it. It was, did the magazine come out? Was it checked? Was it examined?
The question is though, did somebody actually take the magazine out after they had blood on their hands? That's a question that you had.
Yes.
And you took steps to test any suspect marks on the magazine to say, okay, do we have Mr. Barron's blood or anybody else's blood on this magazine?
Correct.
Because if it's on the magazine, that means the person must have done a whole lot with that gun. Must have, maybe even put the bullets in the top and loaded the thing in and then cocked it, right? Blood on the magazine.
Yeah, my question, what I was thinking more along the lines of with that, because you had the live rounds that were laying on the floor, is if the gun was jamming and it had to be cleared versus loading the magazine.
Okay.
I mean, I know what you're asking, but my question was more, did it ever eject from, handled, and then reinserted versus loading?
Okay.
If that's.
The point was you wanted to find out if this magazine ever came out during this whole thing.
Right.
And so you tested it. This is not the actual gun. This is a replica, right?
Yes.
Okay. So I'm not pointing this at you guys. You tested the inside magazine. Hey, does this thing have Mr. Barron's blood on it? That was a question you had, and so you tested it for that.
Yes.
And the answer was no.
Correct.
No blood on the magazine. Correct?
Correct.
You just mentioned something about the jam. Because remember, we've got a shell stuck in the chamber.
Correct.
Right. Once the shell is stuck in the chamber and it doesn't come out when it's fired like it's designed to, and you did some of this yesterday, but I want to make sure everybody knows what we're talking about. When you fire one of these, it's a semi-automatic pistol. When you fire one of these, what it does is the pressure of the shot sends the slide back, right?
Yes.
And it ejects the shell casing. It's
Correct.
functioning properly, right?
Yes.
So you shoot, the thing flies back and throws out a shell casing. With me? That's correct.
Yes.
Okay. And you said this, sometimes it doesn't.
Correct.
Sometimes the shell casing doesn't fly back and get popped out. Sometimes it doesn't fly back, it stays in the chamber.
Correct.
And in this case, that's exactly what happened.
Yes.
Because we found the shell casing still stuck in the chamber.
Correct.
At that point, this gun will no longer fire unless it's clear.
Correct.
And if it's jammed, because there's a shell casing in there, and I'm trying to unjam it, let's say, right? And I put my hand up here on the top of it and do this, I can get my hand caught in there.
Yes. Or on the back, the rear side, yes, you can
You
get
used a
caught.
term for it yesterday. Some sort of pinch or something, bite. You called it something bite, you remember that? When you
I'm
get your
trying.
hand, you used the term, you don't remember that?
I mean, you can pinch it, but not, I don't remember
The term.
yesterday. I'm sorry.
But the point is, if you do this, it's jammed, you can get your hand caught in it, right?
Yes.
And that's what we think happened in this case, right?
Which
Mr.
injury?
Miracle's hand got jammed in the top of the,
Yes, I mean, I saw a photograph later on. I didn't see the hand. So, I mean, but yeah.
okay. It's okay if this isn't your thing, you're doing the crime scene, you don't have anything to do with that, but did you ever look at the injury that she has to her hand right here and try to match it up and say that's consistent?
No, I didn't.
Okay. If I'm trying to do that, if I've got a jammed gun and I'm trying to get it to unjam, okay? And I've got it all the way open this far to try to do that, something else is gonna happen too, right? Meaning.
Which one I'm trying to see what you're, Can I step down and just see? Thank you.
All right. If I've got it, you can come on over here.
I don't want to block your face. Okay.
If I've got it jammed, because there's a shell stuck in the chamber,
Okay.
and I'm trying to get it like this, right? And now I've gotten it caught in my hand, for one. But two, if I get it this far back, some of those bullets can start popping out, right?
Yes, I mean, it's.
Yeah.
All right. Let go. When you're talking about the round being, the shell casing still being down in here.
Exactly.
If it tries to feed and doesn't pull the shell casing out, you can have a round that starts to come up out of the magazine.
Exactly.
Just push from the magazine.
And if I keep doing that, I can have bullets that fall out all over the floor.
You can knock a couple off, or you can knock one at a time out as they're feeding. You can.
Okay.
I mean, I think that's what we're
talking about.
Okay.
Exactly. And I'm trying to unjam this gun, and I've got bullets, let's say, unspent, unshot bullets. I'm using the word bullets. The whole thing. They're coming out. They're falling all over the floor. Possible.
You could, yes, you could have rounds coming out while you're trying to clear the jams.
Chris, what? Everybody's with us, Judge?
Yes.
Showing you defendants 4 and 5. Recognize these?
Yes, I do.
Oh, sorry.
Okay. Yes.
These are Mr. Barron at the hospital after he's unfortunately deceased.
Yes.
Okay. They fairly and accurately represent Mr. Barron on March the 8th when he went to the hospital?
Yes, I do.
Okay. May I tender defendants 4 and 5?
I'm sorry, numbers.
4 and 5.
No objection. I just don't know if you want to cover up this.
Don't, actually. Are 4 and 5 admitted?
Objection.
I'm sorry.
No objection.
Admitted.
May I publish?
Yes.
Now, these do depict Mr. Barron's body. So they're, they are of a nude body, okay? Defendants 4. And defendants 5. Couple things I want to ask you about these questions, about these pictures, okay?
Okay.
One of them is about his genital area, for lack of a better term. Okay?
Okay.
You would agree with me that his genitals appear to be shaved or have had the hair removed from them from some means?
Yes, I mean, they're clear.
And do you have any information about how that took place with respect to Mr. Barron?
No, sir, I don't.
The other thing I want to ask you about is his hands.
Yes.
Here we see that they have evidence bags around them.
Yes, sir.
And that was done by you?
No.
Who was it that put the evidence bags on, if you know?
When he arrived at the hospital, apparently the ER staff did. That was not anything that I did.
Okay. Do you know what the purpose might be for them doing that?
Objection,
If you know.
speculation.
If you know.
Overruled if he knows.
It's just sometimes a standard practice that they'll wrap the hands or bag the hands, so to speak, for trace evidence.
For trace evidence, and the trace evidence can be, trace evidence just means stuff that can be tested related to his hands.
Correct.
It could mean what they call gunshot residue.
It could be gunshot residue. It could be skin or hairs, fibers under the fingernails, cuts or abrasions to the hands.
What evidence do we have that Mr. Barron did not fire the Beretta on March the 7th or into March the 8th?
We didn't do any testing on gunshot residue. So if that's what you're asking.
I'm asking, what proof do we have that he did not fire a firearm on March the 7th or the 8th?
I don't know if he did or did not.
We on 6?
Yes.
First witness?
Yes.
Showing you defendants exhibit 6. Take a look at that.
Yes, sir.
This, you would agree, this is that area where the shooting took place with a new door put in place.
That's what it appears to be, yes, sir.
And obviously it's not this door, but
Correct.
do we have a photo of the outside of the bedroom with the door closed that you're aware of? That you took?
Completely closed?
Yeah.
Not that I'm aware of. I can't remember. There were quite a few shots, but I think most of them, they were.
Door was already
open.
open. Yeah. Without a shot of the door, what it looks like with it closed, is it tough for us to know what it was Miss Miracle was looking at, would you say?
I mean, it would just.
Like that's argument and the judge.
Do you have a response to the objection?
I don't think it's argumentative. I'm just seeing if the witness agrees that we can't recreate for the jury what it was that she was looking at.
Overruled.
Thank you, Judge.
You're standing there looking at a closed door and going into a bedroom.
You
or
don't-
going into a room.
You don't disagree that this is really super probably close, besides it doesn't have a handle. It's probably really
It would
close.
be a closed door. Yes, sir.
Okay, but it's of that exact room.
Yes.
Okay. I'll move to tender defendants exhibit 6.
I don't know that we've established what that is a picture of. And this witness would say it's a true and accurate picture of what it purports to show.
It's demonstrative only. And it's our only means to show what it looked like.
I object.
Okay. Members of the jury, without commenting on any evidence or anything along those lines, there is, lack of a better term, real evidence, meaning things that come into evidence. So for example, and again, not commenting on the evidence, the real Beretta, which is in a box, and then we have demonstrative evidence, which is not real evidence. For example, the mock-up of a Beretta So that's not real evidence. It's just what's called demonstrative evidence. So what defense counsel has in his hands is not quote unquote real evidence, but it's demonstrative evidence. And I will allow it for that purpose and that purpose only.
Thank you, Judge. Unpublished defendant 6, Judge.
Yes.
Thank you. I want to talk to you now, and this is the last thing we're going to talk to you about, okay? I want to talk to you now about how we can divine or infer questions about intent from the defendant to the extent that you can, okay?
Okay.
You don't disagree with me that this shot went through roughly this seam, right?
And I'm going to object as to this shot and this seam is because there's no shot or seam on the door. So he's asking a question with facts that are not in evidence. There's no shots on the demonstrative door. And I don't know which shot he's talking about.
I can fix that.
So I'll sustain that objection. Go ahead.
The shot, the fatal shot, which came from the Glock 9mm, right?
Yes.
Went through the door, right?
Correct.
Then through that wall and then struck Mr. Barron,
Yes.
right? And you've got a diagram of where you think he was. You got that up there? That picture was shot. I think I. Oh, okay, great. States 181, Judge, previously admitted, man, published.
Yes.
This is our, and it's not to scale, and you made that very,
Correct.
very clear. You know, the room is not the size there that it really is, right?
Right.
And none of this is to scale, but the gist of this is we think he's here. We know it goes through the door, through the wall, and then it strikes him right on the side.
Correct.
We know that for a fact that it struck him right here.
Yes.
And then it went into his body and unfortunately struck a major life-preserving artery. Or I think it was, what was it?
Thoracic.
Thoracic. Right?
Right.
She's outside a closed door and makes a shot that you would agree, if it's maybe an inch to the left, misses him completely.
Inch to the left, inch right.
An inch to the left, misses him completely. Or an inch to the right, for that matter.
If it's, I don't know if I would say an inch.
Okay,
I mean,
tell me how far off she's got to be to miss him. And I know that this isn't, you're not telling these folks this is science. I've done a measurement, but you've been to the scene, you've examined the evidence, you looked at this door, you did measurements, did everything.
Well, you're talking about the width of the person too. I mean, you're shooting through the door, it's coming through the door, and it's, let's say the mask.
What is?
No, you're good. Let's just say this is the wall. Okay.
Yes, sir.
The door's right here. You're shooting through at an angle like this. I don't know if an inch one way or the other. Several inches possibly.
Okay.
Okay, but an inch one way or the other is going to miss because you're talking about coming from here, coming through and you're striking here, and I'm several inches wide, so I can't tell you, you know what I'm saying? I can't tell you that an inch in one direction would have not been a fatal shot, or an inch in the other direction would not be a fatal shot. I mean,
You would agree that this is either an incredibly skilled shot if she's intending to take his life. This is a very skilled shot through a closed door where she can't see a thing on the other side.
And I'm going to object. That calls for speculation, Judge.
He's been to the scene. He can give his opinion about that.
State's objection again.
Argumentative and calls for speculation.
Defense response.
He's the expert witness in the crime scene, and he's entitled to give an opinion about these things.
If he knows, I'll allow it. If he doesn't, that's fine.
repeat it one more time. Let's make sure we're.
This is either an incredibly skilled shot from a tremendously gifted marksman, or it's something else.
And something else is a little open-ended, Judge.
Or it's not that.
And that's an ultimate issue question, Judge.
It's not an ultimate issue.
All right, time out. I'm going to authorize the question. Go ahead and ask it again.
This is a skilled shot if she's intending to hit him.
If she's intending to hit him.
Yes. Yes, it is a skilled shot.
Let him answer.
I'm not, my opinion is you're talking about a distance of about 12 inches. Let's say fired from another 6 or 8 inches, whatever, from outside the door. If you're shooting completely blank without hearing anything, seeing anything, you're behind a closed door, you don't know where the person is. But if you are talking or if you are in the middle of a conversation, if you have a sound to shoot at, I don't know if I would call it an incredibly skilled shot. Does that?
With the tool of hearing, a person could find someone in a room through a closed door, is what you're suggesting.
Yes.
Yes.
If you hear somebody talking, if you hear the movement and if I've got something, I'm standing in front of a door, if I'm standing in front of a wall, just blank, I can't see through it. But if I hear something in a certain direction, I know which way to shoot.
If a person then doesn't have the tool of good hearing, it's a more difficult shot.
It could be, yes.
If a person is intending to kill someone through a closed door, why would they only shoot once?
If I'm shooting through the door?
Person who's intending to kill someone through a closed door.
Okay, let's say I'm not intending to kill someone, but if I am, if I was to try to kill someone, or if I'm deliberately aiming for someone, I've got the door closed, I hear the movement, I fire the shot, I hear the person fall, why am I going to keep shooting? I mean, that's...
One got it done.
Pretty much.
If I want him dead, why do I hammer through the door like a maniac to get to him?
And I'm going to object that calls for what was in somebody else's mind and is argumentative and can be saved for closing argument.
Fair enough. Fair enough.
Sustained.
Would you agree that running downstairs, grabbing a claw hammer and bashing through the door to get to him is evidence that she doesn't intend for him to die. Would you not?
Objection, same objection, Judge. It's what was she thinking, and that this witness cannot answer what someone else was thinking.
I think he can give his opinion about what the damage to the door indicates, or could be inferred to indicate.
And Judge, it's speculation as to what was in someone else's mind, not as to the physical evidence.
Okay, so as to what's in someone else's mind, that I'll sustain that. As far as the alleged crime scene, I'll authorize that, but that's the ruling.
Okay. I said that was my last area, but we're gonna do one more thing. I'm sorry. Would you mind if we can set this up? I'll do it with you. Justin, can I set up the door?
Let's take a 15-minute break and then we'll come back. Thank you. We're in recess till the jurors are ready. Thank you.
Six.
All right, thank you so much. Please be seated. Continue with examination, please.
Investigator, before I let you go, I wanted to talk about specifically the trajectory of the fatal shot that went through the door that we see here. And you've marked this. I don't know what number it is. I'm sorry.
It's 198.
The door is 198, Judge. One of the first things that you did when you were working with 198, well, first, you took it with you, obviously, from the scene.
Correct.
You unhinged it.
Yes.
Okay. And you took it from the scene and brought it back to your lab and have had it there until now, until yesterday when we brought it over here.
Well, it's been in the lab and property and evidence. It's been secured.
And the first question, or one of the first questions you had was, what is the angle of the shot through the door, right?
Right.
And this is, this is not a to scale angle here, but this being 90 degrees is straight up.
Right.
And 0 degrees is
flat.
And the angle that you calculated through that door is, I think you said 5 degrees or something like that?
The angle through the door directionally will be approximately 64 degrees. You're talking about.
I'm talking about rise.
The rise and incline is 5 to 7. Yes.
Okay. And I'm going to do a really bad job of drawing 5 to 7, but it's real close to flat. Fair?
Fair.
Okay. I'm showing you Defendant's Exhibit 7 as a demonstrative. This is a plastic replica of the Glock 43, correct? Which is the one that had the solid
Full metal jacket.
projectile, and it's torn, so it's safe and can't hurt anybody. Fair?
Yeah.
And the first thing we notice about this gun is the barrel is incredibly short, right?
It's a shorter barrel, yes.
And in comparison, let's say to, our Beretta, right?
Yes, the 43 is a compact.
Compact. It's a tiny little short barrel. You can't really get a gun much shorter than that, can you? I'm sure you could, but the stuff that they sell at the store.
That's a standard compact.
Compact. Okay. And it's got a shorter barrel than the other pistol in this case, and that, of course, affects certain things because it's a shorter barrel, right?
Right.
Am I correct that it's harder to be accurate with a shorter barrel than it is with a longer one?
Longer barrels are more accurate for distance shooting, but again, what you're talking about, a small one like this, close range, it's not as effective.
Okay. So what we know is at the time the shot is fired through this door, it's almost flat at 5 degrees.
It's a narrow angle, yes.
I'm sorry, I missed that.
The up or down angle.
The up or down, yeah.
Yeah, it's at 5 to 7 degrees.
Right. In other words, it's not like that. It's not like this.
Right.
It's almost flat at the moment that it's shot.
Yes.
Right. We don't know anything about how the gun was being held in the moments before the shot. What we know is at the moment it's shot, it's almost flat.
Yes.
Right? We don't know if it's doing this in the moments before it's shot, based on what we have, right?
No, the only thing you've got is the entry angles.
You've got the very instant that the projectile is fired outside the gun. That's what you have.
Right.
It's locked in time. That very instant is locked in time by this trajectory through the door. Right?
Yes.
Okay. In other words, if it's like this, moments before I'm about to do it, if it's like this, you don't know if that's true or not. Could be like this.
Yes, I mean
it just ended up here.
Right.
If it's like this, you don't know that either.
Objection. This has been asked and answered 3 times now.
We're doing a different
With the
motion.
shaking.
Bouncing, circling. I mean,
Okay, so I'll sustain the objection. You can ask it another way, but I'm sustaining the objection.
You don't disagree that this evidence is consistent with, it could be, shaking up and down.
I've got the angle coming through the door. I mean, it's
Gotcha.
when the shot was fired, it's at this angle.
Gotcha. But it's not inconsistent with even this. Just at the moment it's fired, it's right there.
It's right there. Yes.
Okay. What we do know for a fact is when you shoot a gun at a piece of metal, let's say, that bullet can ricochet and go pretty much everywhere.
It can ricochet, it can fragment, it can penetrate.
It can,
it depends on what type of metal you're talking about versus.
Sure, and there are variables, is what you're saying.
Right.
Yeah, and so like in this case, one of the shots we know hit that, you called it a picket, which is just the another word for it is baluster, as far as I understand. The little outside the room, one of the shots that was fired from the
Yes.
hit a picket and just, I mean, it went absolutely everywhere, right?
Right.
I mean, stuff flew out. There's pieces of the projectile out in the living room, right?
Correct.
There's stuff that flew down the hallway,
Correct.
right? All up on the ceiling of the hallway. I mean, this thing, it just shattered and went everywhere.
Right.
From hitting one piece of metal.
Right.
You obviously know that because you have experience with firearms.
Yes.
Right. Someone with knowledge of if you shoot a piece of metal, that it could ricochet and go anywhere, that might give them concern, just like it would give you concern.
It could.
You wouldn't shoot at a piece of metal super close up. Fair?
It depends on what I'm trying to do with it. I'm sorry.
All right. Okay.
I'm not going to shoot at a steel target up close, but if I was trying to get through something.
Okay. All right. Thank you.
This is beyond redirect, Your Honor.
I'm sorry.
Okay, I just have some questions.
Sure, absolutely.
Okay.
Does that need to come down? Or?
Nope. So looking here at State's Exhibit 198, the door, and let's talk a little bit about the gunpowder. Could banging on this door knock off gunpowder?
Yeah, any kind of blow to it, if you're hitting the door, striking the door, it could cause some of the gunpowder to bounce off or come off. Yes.
Could banging on the door repeatedly in two different places near where the gunpowder was knock off the gunpowder?
Yes.
Could reaching your sleeved hand through a hole wipe off the gunpowder?
It could. And with the blood on the back of the door where it looks like the body was pushed, if you're having to push the door, put your arm against it, this area right in here, there's a good chance. That's why I'm looking at the stippling versus powder.
Okay, and so it sounds like you're saying that movement against the door could knock off gunpowder.
Yes.
Movement of the door could knock off gunpowder.
Yes.
So a paramedic brushing against the door could knock off gunpowder.
Yes, a first responding officer. So.
The defendant pushing the door open could knock off gunpowder.
Yes.
Okay. And so you can seat back up. So is it fair to say that when you are making your opinion or your determination about the stippling, are you looking at gunpowder?
No.
What are you looking for?
Like I said, the gunpowder can be wiped away. The stippling is actually the impacts into the surface of whatever you're looking at, whether it's, in this case, the door, clothing, or skin.
And when you made your determination, when you looked at the door at the scene, did you make a determination at that time before doing the test fires of what your opinion of was from the muzzle of the gun to the door?
Observing the stippling, I thought it was going to be pretty close. Yes. I mean, I did notice the stippling there. I didn't notice gunpowder on the door, but I did notice the stippling.
And so when you viewed the door at the scene and you looked at the stippling, what was your
I was pretty much what I still think now is about 6 inches away.
okay. And so then did you later do anything to confirm that opinion?
I did do a demonstrative type firing into a door panel, yes.
Okay. And so tell the jury about what you did.
We cut a level door panel, or we cut a door into sections where we could mount it up onto basically this frame with a little bit more added to it. The door was leveled up the gun was placed into a vise. We worked on getting the angles similar to the 64 and the 5 to 7 degree upward angle. And it was shot, test fired from the vise at 6 inches and 3 inches.
Okay. And so where did you do that?
It was at the Hall County range.
And you didn't use this door?
No.
So I'd like to switch over and use the Elmo. Okay, and I think we're going to go ahead and take the door down now because I don't want to obstruct the juror's vision. Yeah. Is this thing good? Okay. Oh.
Thank you.
So when you were when you did your testing, I'm sorry, where did you say you did it?
It was at the Hall County range.
Okay, so when you were at the range doing the testing on a different door, how many settings did you, how many distances?
It was
did
a
you test?
3 and 6 inch.
Okay. So I think that Mr. Willis showed us the 6 inch. So let me show you what I've got marked States Exhibit 200. You recognize that?
Yes.
What is that?
It's a photograph showing the test fire at a 3 inch distance.
Okay. Judge, State Tenders Exhibit 200 into evidence.
Hearing no objection, it's admitted.
Objection, sorry.
All right. So can you tell the jury what we're looking at here in State's Exhibit 200?
You're just looking at the powder around the entrance, but you can also see the stippling, how the impacts into the paint are closer, they're tighter, where with a 6 inch, it was backed up and it was more consistent with actually what we see on the door, or in my opinion, what I see on the door.
So then looking back at Defense Exhibit 3, that's the 6 inch pattern?
Yes.
And so based on the test fires that you did you form any different opinion, or what was your opinion about the stippling and the length from muzzle to target on the door, in this case, State's Exhibit 198?
No, when you saw the stippling there on the scene, it was my opinion that it was relatively close, probably within a 6 inch. And the test fires just confirmed it.
Okay. So now I want to ask you, looking at State's Exhibit 43, I'm going to turn it around here. And then in connection with State's Exhibit 43, looking at State's Exhibit 45. Now, looking at the footprints and the blood spatter that's on the bedspread, could that blood evidence be consistent with a person entering the room with the gun and with the holster, unsnapping the holster and throwing it on the bed?
Yes, I mean, The blood that's there is just basically dripping down. The holster itself had blood all over it, like it had been gripped, but you're talking about unsnapping it with bloody hands and just setting it onto the bed. Yes.
So I think Mr. Willis had asked you about a scenario where the gun's already in the room, but it would also be consistent with a scenario where the gun came into the room and the holster was laid under the bed. Is that correct?
Yes.
Now, we touched a little bit on cross on the paper bags that were on Mr. Barron's hands.
Yes, ma'am.
Would testing for gunshot residue on Mr. Barron's hands be of any evidentiary value in this case?
Not in this case. My understanding is that if you're in the room when a gun is fired, you don't necessarily have to be the one that pulls the trigger to get the powder on your hands or on your body. A lot of times we can't get testing done on someone who is a victim because the lab will say that they were there, they got shot, so we expect to find powder on them or gunshot residue on them.
Okay. And do you know, as far as the casings and the live rounds that you found in the septic tank, do you know if you found all the projectiles, casings, and fragments?
No, I don't think we found all the projectile fragments. And as far as shell casings, I'm not sure. Like, we found some items in the septic line, but I'm not sure if that was all that was there or if some had already gotten into the septic tank.
And in your opinion, did this crime scene look altered?
Yes, I mean, there were the fact that the shell casings were missing from the scene, later found in the septic tank, it did show that there was manipulation of the scene at some point.
Okay, and what about the bloody footprints?
The bloody footprints are a person walking around without the shoes. I mean, they're the bloody footprints are the ones that are going through the blood, walking around in the scene itself. There were a couple going down the stairs. So it's movement with someone walking through the blood.
Did you find some bloody footprints in the bathroom in that guest bedroom up there?
Yes.
Okay, that's all the questions I have.
Just a couple of things that I want to make sure we're super clear on. Specifically with respect to, you said bloody footprints going down the stairs. Okay.
Yes.
You are aware, and you probably have seen the first responders, body cameras and all that, that when Miss Miracle was called down from the bedroom, she came down those front stairs.
Yes.
And was barefoot.
Yes.
And there's bloody footprints, presumably from that travel.
Right.
You're not saying, to make this abundantly clear, you're not saying there's bloody footprints from her going downstairs earlier, meaning before the cops show up.
I can't say when the footsteps were deposited going down the stairs.
Well, it's only one set.
Right.
Okay. And we know she comes down when the cops call her down because you see her on the camera.
Right.
Okay. You're not saying there's a second set of bloody footprints that proves she was running downstairs with bloody feet before the police show up?
No.
Okay. One last thing that Ms. Bagwell asked you about was gunshot residue, and she had some questions about whether it'd be valuable and stuff like that. Okay, so I want to ask you a couple follow-ups, okay?
Okay.
I think you said that in cases where somebody has been the recipient or victim of a shot, like this, the lab, meaning the people that do the actual testing, those folks will say, well, we're not going to test for gunshot residue because in cases where you've been shot, that residue is going to come hit you anyway.
You expect to find it, yes.
You'd expect to find it. Person gets shot from a gun at close range, and it could spray residue on them. And so therefore the lab says, there's no point in us doing GSR or gunshot residue. There's no point in doing that because they're going to have residue on them anyway.
Right. Research, from what I understand, is if a gun is fired inside a room and somebody walks into the room within a few minutes, you can still actually get gunpowder residue from walking into the room.
But of course, in this case, the shot was fired behind a closed door, right?
Right.
Gunshot residue is not going to go through the door and get onto Mr. Barron from that shot.
I'm not sure how much would actually travel through. You're going to have a little bit that's going tracing the bullet, but I mean, I wouldn't expect to find a lot, no.
We're going to have to be satisfied, is what you're saying, with the fact that nobody tested Mr. Barron's hands for gunshot residue.
No, they weren't tested.
And that's a decision that you made or that someone else made?
I believe we asked the lab to check his hands, and they may have done a GSR kit on him, but I'm not sure. It was never processed, to my knowledge.
I guess I'm just trying to find out who made the decision to not do the test, if you know.
I don't know.
Last thing, I think when Ms. Bagwell was asking you about the stuff that got flushed down the toilet, I want to make super clear that everybody knows that fragments weren't flushed down the toilet. Fragments of shots.
We didn't find any fragments of the shots.
That's what I'm getting at. That's what I'm getting at. You're saying it's possible that somebody could have gone around and picked up some fragments and also.
Yes, because we're talking about the rounds that we were talking about scattering.
Yep.
You had the copper jackets. There were a good bit of copper jacket fragments, but the lead core, I could not find the fragments of lead core.
What we know for a fact is what I want to talk about with respect to the stuff that got flushed, okay?
The only thing that we recovered from the septic line is going to be the live rounds and the shell casings.
Live rounds and shell cases. Live rounds and shell casings is what you found in the septic lines.
Yes.
Okay. And of course, this is a house that's in North Hall County, right?
Yes.
It's not on, city sewer. It's not on the city's sewer.
No, it's got a septic tank.
It's got a septic tank. And for most people know this, but I just want to be super, super clear. If you have a septic tank, it doesn't go and leave the property. It stays in the septic tank.
Yes.
And what you're saying is we went through the pipes, but we didn't go into the septic tank, and there might be some stuff in there.
Correct.
Okay. Okay. Thank you.
No further questions.
Statement, this witness be excused.
Yes, Judge.
Defense.
Yes, Your Honor.
Thank you for your testimony. You're excused.
The state calls Bryson Miller.
Defense, could you move your easel when you're not using it, please? Thank you.
Disconnected. It can take 2 seconds back to it.
I'll leave that to you. It just doesn't need to be in the middle of the well of the court on a new witness. Thank you.
If you may, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you. You can have a seat. Can you please introduce yourself to the jury?
My name is Bryson Miller, BRYSONMILLER.
Where are you currently employed?
I'm employed with the Georgia Bureau of Investigation, or the GBI, also known as the State's Crime Lab.
How long have you been employed there? And if you don't mind pulling your microphone toward you and speaking into the microphone, that would be great.
Yeah, sorry. I've been employed for a little over 4 years now.
What's your role?
I am a forensic serologist.
Forensic serologist. What does a forensic serologist do?
As a serologist, I screen items of evidence for bodily fluids, specifically blood, semen, and saliva.
Can you describe what kind of education and training that you received to become a forensic serologist?
Yes, I have a bachelor's of science in biology from the University of Georgia. And since starting at GBI, I received intensive in-house training that involved the review of lectures, PowerPoints, and literature reviews that I was then tested on. I had written exams, oral exams, and practical exams to simulate casework, all of this to ensure my competency.
I'd like to talk to you about your role in this case. How did you get involved?
When a case is submitted to GBI, a request is open, and depending on what that request is, it can be assigned to me. If it's what we call a blood request or saliva or semen exam, it will be assigned to me.
What were you requested to do in this case?
For this case, I received a blood request on 2 swabs.
Okay, I'm going to show you what's already been tendered as states 196 and 197. Can I approach? Yes. Thank you. I believe that they are already open.
Okay.
Are these the swabs that you received?
Can I refer to my notes?
Yes.
Thank you. All right. Yes, so GBI item 17, I can recognize by my initials and date of the date I tested them. They also have the unique GBI case number, and the same thing for 18. Yep, so my initials and date, I know you can't see, but, and the unique case number is how I'm able to identify them.
Okay, I can take them back.
Okay, thank you.
So, do you know what the swabs, what was swabbed with those swabs?
Of course, I wasn't there when the swabs were collected, but when they come in, they're labeled on the box, and they were labeled as GBI item 17 was labeled as being collected from a firearm magazine, and GBI item 18 was labeled as being collected from a holster.
Did you receive any firearms in this case to be tested?
I believe that some firearms were submitted, but they were not associated with the blood request, so I did not do any testing on any direct firearms.
Okay, so you receive a sample, in this case swabs. What's your first step when you receive a specimen or swab to be tested?
Yes, so for a blood exam, the first thing that I'll do is I will open the item and look over the swabs, specifically for any reddish brown stains that could be characteristic of blood. If I locate those stains, I will then complete our chemical examination, which is 2 chemical color change tests that I complete at the same time by taking small cuttings of the swabs and then adding chemicals to those cuttings. And a color change will occur immediately to indicate the presence of blood. If no color change occurs, that item is considered negative, or it fails to reveal the presence of blood.
Okay, so you said 2 color change tests. What are the names of those tests?
One test is the tetramethylbenzidine test, or the TMB test. The other is the phenolphthalein, or the PHE test.
Do they both test for the same thing? For blood?
Yeah, they are screening tests for the presence of, we use them as a screening test for the presence of blood, correct? It's important to note that these tests are presumptive tests, though, which just simply means that they have false positives or other substances that can give a positive result. Specifically for the PHE test, those false positives are nickel, copper, fresh flour, fresh horseradish. Sorry. And for the TMB is rust, mustard, garlic, potassium cyanide, and tomato. Now, the important note here is that blood is the only known substance that these two tests share, which is why we do both of them, to greatly reduce the risk that a positive result we obtain is a false positive.
Okay, so if you have a presumptive positive for blood, do you then test for whose blood the sample belongs to?
I personally do not. So in instances when an item screens positive, if it is eligible, it can move forward to DNA testing, where they will test to see who the blood belongs to.
So here you had 2 sets of swabs, one from a holster, one from a magazine. Did you run both of those tests on both sets of swabs?
Yes, as part of the blood exam, I completed it. I completed the blood exam on both swabs.
Okay, so with regard to the swabs for the magazine, what did you conclude?
The swabs from the magazine, or GBI item 17, failed to reveal the presence of blood or were negative.
And what about the holster?
The swabs from the holster indicated the presence of blood or were positive.
No further questions.
Defense.
I'm finished questioning him.
You may be excused. Thank you for your testimony.
Thank you.
State calls Martin Gravely. Yes, yes.
Welcome. Thank you. Come on up. Thank you.
It remains standing.
Do you swear or affirm that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, please. Can you introduce yourself to the jury?
My name is Martin Gravely III. It is spelled MartinGravely.
How are you employed?
I'm employed with the Georgia Bureau of Investigation in the Division of Forensic Science as a firearms examiner.
How long have you been with the crime lab?
I've been with the crime lab since 2022. I started as a laboratory technician, and in April of 2023, I was promoted up to a crime lab scientist as a firearms examiner.
As a firearms examiner, what are your duties?
I examine firearms to determine if they are operable, if they function properly. I also am able to determine if fired ammunition components, such as bullets and cartridge cases, were fired from a particular firearm.
What is the education and training that allows you to be a firearms examiner?
I received a Bachelor's of Science in Forensic Science from Piedmont University. I also, once I was promoted to crime lab scientist, I then went through a roughly 15-month to a year-long to a 2-year-long training program in-house, which dealt with manufacturing processes of making firearms and different manufacturing processes of bullets and cartridge cases, as well as comparison microscopy, which is where we use a comparison microscope, which is similar to that of a compound microscope that you might find in a biology lab. We use those to determine if a bullet or cartridge case was fired from a particular firearm. After that, I then went through a roughly 7 months to 1 year long period called supervised casework, where I did real cases under the direct supervision of another fully trained examiner who reworked my case to ensure that I did everything properly. After that, I became an independent examiner.
Have you ever testified as an expert in firearms examination or firearms identification?
I have.
How many times?
6 times.
Judge, the state tenders Martin Gravely as an expert in firearms examination and identification.
No objection.
So ordered, folks, again, experts are here to assist you in your task as finders of fact. Just like any witness, any credibility or not credibility is solely for you to decide. Proceed.
Can you explain to the jury what firearm identification is?
Firearm identification is the branch of forensic science that deals with identifying whether or not a particular bullet or cartridge case was fired from a particular firearm.
And what specifically is a firearm?
A firearm is an action, or it is a machine with a type of action that triggers specifically that when it is pulled, it uses the products of combustion to propel a projectile down the barrel of a firearm.
What are the different types of firearms?
So there are long guns and handguns. Long guns are your shotguns and your rifles. They're typically designed to be fired from the shoulder with 2 hands. And then your handguns, there are several types. The primary ones are pistols, which are or semi-automatic pistols, where you use a magazine and you insert it into typically the grip, and it's designed to be fired with 1 hand. Good firearm safety says you should fire it with 2 hands. And when you fire it, it automatically ejects the cartridge case from the firearm without use from the shooter. In contrast, a revolver has multiple cartridges inserted into a cylinder that is raised into in line with the barrel and the firing pin or hammer. And so when you fire it, you have to manually remove the cartridge cases from the cylinder. So that's the primary difference between those 2 firearms.
What do the terms single action and double action mean?
So single action both of them refer to what happens as you're pulling the trigger. And so with single action, it means when you pull the trigger, one thing happens. So typically when you pull the trigger, the hammer falls, detonates the cartridge. With double action, you will pull the trigger and it will cock the hammer. And as you cock the hammer, once the trigger is fully pulled, then it will release the hammer, striking the primer and detonating the cartridge. So single action, 1 action happens, it just drops the hammer. Double action, 2 actions are happening, it cocks the hammer and then releases the hammer.
How are you able to determine if a bullet or cartridge case was fired from a particular firearm?
So like I said before, I use a comparison microscope. It is like I said, a compound microscope joined together by an optical bridge. It has 2 stages on it that I'm able to manipulate. And so I will be able to look at 2 fired ammunition components, specifically a cartridge case or a bullet. And I'm able to view them at the same magnification under the similar lighting. And what I'm looking for, I have a demonstrative if it would help the jury figure out a bullet versus a cartridge case.
Would that be all right, Judge?
I don't even know what it is, and I haven't heard an objection, so that's fine.
So typically, this is what most people would consider to be a bullet. The bullet is only this part. The entirety of it is what is called a cartridge. A cartridge is a single unit of unfired ammunition. And so it consists of the bullet, the primer, which you can see here, the cartridge case as a whole, and then there's gunpowder inside. And so when the firing pin or when the firearm's trigger is pulled, the firing pin is released and it strikes the primer. And when it does that, a spark then travels through what is called the flash hole, which you can see here, and it ignites the gunpowder within, causing rapid gas expansion. That rapid gas expansion pushes the bullet out of the mouth of the cartridge case and into the barrel. So I'll get to that in a moment. But with the cartridge case, when that happens, it is pressed back into what is called the breech face of the firearm. The breech face is just where the cartridge case sits in the firearm. And so when it does that, it leaves a negative impression of that breech face on the cartridge case. It is also then grabbed by the extractor, and it's pulled back through the force of the rapid gas expansion, and it strikes what is called an ejector, and it hits and it's kicked out of the firearm. The bullet, on the other hand, as that's happening simultaneously, the bullet travels into the barrel of the firearm, and it engages what is called rifling. Rifling are raised and lowered lands and grooves in the barrel that give a twist to the bullet that allows it to spin, granting it more accuracy. So all of these areas that I just discussed, the rifling, the breech face, the ejector, the extractor, the firing pin, all of these things leave behind marks that are created during the manufacture of each of the items. Each of these items have individual characteristics, which are microscopic imperfections created from the manufacture of those parts. It's also from wear and tear. And each of these individual characteristics are similar to that of the firearm's fingerprint. And through comparison microscopy with my comparison microscope, I can compare these two items to see the individual characteristics from one bullet or cartridge case to another. And that's how I'm able to determine whether or not a particular firearm fired bullets or cartridge cases.
Okay, and I heard you mention the individual characteristics. Is there something called class characteristics?
Yes. So class characteristics are characteristics that the manufacturer of the firearm intend to make. So for example, Glock, typically, unless it's a 45 caliber Glock, their rifling structure will have six lands and grooves with a right twist. There are other firearms, such as High Point comes to mind, with a 3 lands and grooves with a left twist. These are class characteristics that help narrow down from a general pool of firearms that could have fired any of these bullets or cartridge cases to a much smaller list. There are other types of class characteristics, such as firing pin impression shape. There are circular or hemispherical. There are elliptical or teardrop apertures and whatnot. These all help assist narrowing down a large group of firearms into a smaller group, into a smaller group, into a smaller group, but no identification can be made off of just class characteristics alone. We have to look at the individual characteristics.
Okay. And was evidence submitted to you by the Hall County Sheriff's Office in this case?
It was, yes.
I'm gonna show you what's marked States Exhibit 187. Recognize this.
I do. It is a Glock 9mm handgun. I recognize it by the unique Division of Forensic Science barcode that is affixed to all items of evidence at the GBI. This one is 2025-1007495. I also recognize it because I see my initials from where I sealed the evidence. I also recognize it by my initials on the firearm itself and the magazine. I also can see the serial number present.
And now I'm going to show you what I've got marked States Exhibit 190. Do you recognize that?
I do recognize it. I recognize it as a Beretta 9mm firearm. Again, with the Division of Forensic Science barcode on it, as well as my initials on the box, the trigger guard, and the magazine, as well as its serial number, which is on the other side of the firearm. But I recognize it through all the other indicators.
And I want to show you what I've got marked, States Exhibit 191. Do you recognize this item?
I do. Again, it is one 9mm cartridge case. I recognize it from the the Division of Forensic Science barcode and my initials.
And I'm handing you what is marked States Exhibit 189. Do you recognize that?
I do. It's another 9mm cartridge case. I recognize it again through my initials as well as the barcode.
And States Exhibit 192.
This is another 9mm cartridge case. Again, I recognize it through the barcode as well as my initials.
And States Exhibit 188.
This would be a bullet that I identified to be a 9mm bullet. I recognize it with my initials as well as the Division of Forensic Science barcode.
And looking at those items, States Exhibits 187, 188, 189, 190, 191, and 92, did you receive those? What date did you receive those at the crime lab?
I received them on, I received the bullet on March 12th of 2025, and I received the firearms and the cartridge cases on May 15th of 2025.
Okay. And had these items been previously submitted to the crime lab for testing by someone other than yourself?
I believe so, yes.
Okay. Can you explain to the jury what outsourcing is?
So typically with an outsource case, we will send it off to because we had so many cases at the time, we would send some of these cases out to an outsourced agency to run their own experiments or run their own, collect their own conclusions and findings, run their own experiments on it. They will generate their own test fires and they will come to their own conclusions. And then they will be sent back to us and then we will release a report based off of them. If and when those cases then go to court, they will be reworked in-house by a trained examiner through the GBI. And that is what happened in this case.
So when you received these items, States Exhibits 187 through 192, what did you do with the items when you received them?
When I received the items, I examined the cartridge cases and bullets first to determine their class characteristics. So again, back to what I was saying earlier about leading from these cartridge cases could have been fired from any number of firearms to trying to narrow that list down. I looked at the firing pin impression shape or the rifling structure. And if they had the same class characteristics to the firearm, I would then test fire the firearm to then compare them microscopically to determine if they were fired from the same firearm. So I looked at the cartridge cases, found that they did have the same class characteristics. So then I test fired the firearms and then I compared the test fires to the evidence items. I compared them to the test fires.
And so did you reach any conclusions? First, let's start with item 8. Your item 8, which is our Exhibit 188.
I did reach a conclusion with the bullet, item 8. It was fired. Item 8 was fired from the firearm. My item 12.A, which is States Exhibit 187. based on class and individual characteristics.
Okay, and is your item 8, which is our 187, which gun is that?
That would be the Glock.
Okay, so so we've got the projectile that was recovered from the medical examiner was fired from the Glock. Is that correct?
That's correct.
Okay, and then did you make any findings concerning the Beretta, which is, let's see, our exhibit 190 and your item number 13A?
I did. I found that both the Beretta and the Glock were operational. I also found that the cartridge cases, my items 14 and 16 were fired from the Beretta, and their States Exhibit 191 and 192.
Okay, and what are those? What actually are those? What are States Exhibits 190 and 192?
They're 9mm cartridge cases.
Okay. And so then did you make, let's see, also concerning the Glock, did you make any conclusion about the cartridge case that is item 15 for you, and 189 is our exhibit number?
I did. That cartridge case was fired from the Glock.
Okay. So did you do any other testing on the firearms?
I determined that they were operational, so I did what is called a check function test, where when I test fired the firearms, I ensured that they were operational. With the Beretta, I also did what is called a bump off or push off test. Because it has an exposed hammer, what I will do is I will check the hammer at all configurations. So it has a half cock and then a full cock. And then I will try to, with hand strength, push it forward to try and determine if the hammer will be removed from its position without pulling the trigger. I did those tests. It passed, meaning that the hammer did not fall. And there's another test that I did not perform because as a functional firing pin safety, it's called a bump off test, where we keep the hammer at rest and we strike it with a hammer, or a rubber mallet rather, to determine if it will detonate a cartridge. But again, I did not perform that test because it has a functional firing pin safety and it could damage it.
Okay. And looking at States Exhibit 190, which is the Beretta, is there a safety on that?
The Beretta did have a number of safeties, yes. It had a manual safety, which is it is a slide mounted ambidextrous safety, where when it is faced up like this, and there's a little red dot, the firearm is not safe. The safety is disengaged, which means that the firearm can fire. When the safety is engaged, it physically pivots and it disconnects the sear and trigger assembly, meaning that it literally will move it. So if it's set like this to where the firing pin can be struck, it moves it like this to where the firing pin cannot be struck. It also decocks the hammer and acts as a decocker. So if you had the hammer ready to fire and you activated the safety, it will fall and not detonate a cartridge.
So it sounds like you're saying the Beretta has a manual safety.
That's correct.
And that if you don't disengage the safety, what happens?
If you do not disengage the safety, meaning that the red dot is present, the firearm could be shot.
It could be shot.
It could be, yes, if you pull the trigger.
Okay. So if the safety is engaged and you pull the trigger, what happens?
So because it disconnects the sear trigger, or because it disconnects the firing pin or sear trigger linkage, essentially the trigger will just move, but it will not do anything to the firing components. It will not activate the hammer. It won't do anything. Essentially, it renders the firearm inert.
Okay. And does a Glock have a manual safety?
No.
did you perform any trigger pull tests?
I did.
Results.
So a trigger pull test, before I get to the results, a trigger pull test is essentially we take, if you've been to a grocery store and you put your fruit on one of those scales, it's very similar to that measuring device. So what I'll do is I'll take the hook part and I will put it into the trigger, and then I will hold it in a normal position, and I will pull it to determine the weight that it takes to pull the trigger. So I did that with both the Glock and the Beretta. And my findings for both of those, the Glock had an average trigger pull of about 5.75 pounds, which is the equivalent of about a half a gallon of milk. And the Beretta, it has single action and double action, similar to what we discussed earlier, where if you do the single action, all you're doing is pulling the trigger and the hammer is released. That trigger pull weight was about 4.5 pounds, and the double action one was about 12.75 pounds. So 10 pounds would be about a full gallon of milk.
Okay. And then did you say what the trigger pull on the Glock is?
Yes, I did, but I can repeat it. It is about 5.75 pounds.
Okay. And now talking about the Beretta specifically, if there were a total of 4 unspent rounds matching the ammunition, the same ammunition that was located in the Beretta, based on your training and experience, what events could cause those live rounds to come out of the firearm without it being fired?
The way that I would expect cartridges to be removed from a firearm unfired would be having to rack the slide. Racking the slide being when you hold the firearm either with your right or left hand. I'm right-handed, so I'm going to do it like this. When you rack the slide, you pull the slide, which is the top part of it, the metal part typically, you pull it rearward. And by doing that, the extractor is going to hold on to the cartridge head, like what my hand is doing, and it's going to pull it and kick it out. So if you don't fire the gun and you rack the slide, it will remove the cartridge that's from the chamber, provided it's the correct ammunition. Another way is if there is no magazine in the firearm, and again, you rack the slide, but you don't have enough strength, it could be enough to possibly remove it from the chamber and get it to fall out. But again, you would have to rack the slide no matter what.
If a person unfamiliar with the Beretta left the safety engaged, could that contribute to live rounds being expelled?
Not necessarily. If the safety is engaged and they're I can't testify necessarily to unfamiliarity, but if the safety is engaged and you're not ready for that, and you expect the trigger to detonate the cartridge, one may go to try to rack the slide. So it's possible, but in the event of the safety being engaged or disengaged or engaged does not necessarily mean that the cartridge will come out, but someone will have to rack the slide.
Okay. And would it surprise you if there was a spent shell casing located in the chamber of the Beretta when it was cleared by the crime scene?
That I'm familiar with where the casing was from the firearm. In the event of a normal firing situation, that would be surprising, yes.
Do you have an opinion based on your training and experience, how it might be that a spent shell casing would be found inside a gun like a Beretta when the chamber is cleared?
The only way that I could see a casing remaining within the firearm after the firearm has been shot is if there was a jam, or that's about the only way that I would expect it. Because like I said, the extractor is going to grab the head, and provided it's the correct ammunition for that firearm, it's going to grab it and kick it out. After it's fired, there shouldn't be a cartridge case within the chamber, provided everything goes correctly.
Okay, that's all the questions I have. Thank you.
Just a few questions, okay? Specifically, I want to just talk to you about the Beretta. Okay?
Yeah.
You said that if the Beretta is functioning properly, once it is fired, the casing should be ejected.
Yes, that's correct.
Because it's designed to function that way. That's how it functions. It fires and then it ejects the empty casing.
Yes, that's correct. That's how semi-automatic pistols function, yes.
And if it doesn't, that just means there's been some problem with the gun? Is that what the idea is?
Not necessarily. If you're unfamiliar with firearms, or if you're unfamiliar in general, if you're unfamiliar in general with firearms, you may have what is called like a limp wrist when you're shooting, or if you're shooting with the wrong hand, you may not be ready for that recoil. And so when you hold a firearm to shoot, if you have a limp wrist, it might mess up the timing of the extraction and kicking it out of the firearm, which could cause malfunctions such as like a stovepipe. But provided that you're using the firearm properly and you have a firm grip, everything should function properly, provided that the firearm is operational.
Some sort of, in other words, what you're saying is it can stay in the chamber because the person who's firing it is not holding it firmly enough.
Not necessarily the chamber. I would expect it to remain
the barrel.
No. So I would expect it to remain within that area. So when it comes to a firearm, there's the barrel, which is the part where the bullet travels through, and then there's the chamber where the cartridge sits. So they're two separate, they're attached by the same metal, but they're two separate areas. And so when it fires, the cartridge case comes back and ideally comes out of the chamber and gets kicked out. Now, if there's a limp wrist or if the firearm is malfunctioning, the recoil still should act on the cartridge case to the point where it comes out. It just may not, because of the timing, it may get stuck in the ejection port, which would cause a stovepipe, which would look similar to this, with the slide not being fully pushed back or forward, and it just stuck kind of like this out of the gun.
And just, I'm going to use this sort of replica. Okay. What you mean is it would try to eject it, and then it would be sticking up. The empty shell would be sticking up, basically poking out of here.
That's correct. Yes.
Yeah. That's what you call stovepipe.
That's correct. It's a failure to eject malfunction.
And I'm talking about where the shell casing is still actually in the barrel.
Right. I would not expect that from it, provided that the ammunition is correct. I would not expect that kind of a malfunction. I would expect more of a failure to feed malfunction where the slide tries to take another cartridge out of the magazine. So there's two cartridges trying to fit one hole. Or like I said, a failure to eject, which is more of a stovepipe. I would not expect that.
I want to ask you now then about I think you were talking about when actual full, I'm using the word bullets, but that's not the right word. The whole thing is called a?
Cartridge.
Cartridge. The whole cartridge is situations where the whole cartridge is actually coming out of the gun out of the top, okay?
Mm-hmm.
And I think you said in order for that to happen, this thing has to be pulled back to slide. Right?
Yes, for a full cartridge to be ejected from there, it has to be pulled back. Yes.
Are you calling that a rack?
Yeah, racking the slide. Yes.
If you've got a shell, if you've got a cartridge stuck into the barrel, okay, so it didn't function the way it's supposed to function. You still got a cartridge in there, and you rack the gun. Am I correct? Cartridges can come out from racking the gun.
It's possible that would be what I call that would be called a failure to feed malfunction, where essentially there's still a cartridge case within the chamber and another cartridge comes up, but it can't go entirely in there. So typically what will happen is the slide will try to move forward and you would have to, again, pull the slide back to remove the cartridge. Typically, you should drop the magazine to do all of that if you want to clear the actual malfunction itself. But yes, that's possible.
Gotcha. Okay. Thank you.
Would it be possible for someone to stick the spent shell casing back in the gun?
Yes, it's possible.
And did you find any stove piping on the shell casing that from the Beretta?
I saw no damage that would indicate any kind of stovepipe or any type of malfunction from the cartridge cases.
If you were holding the Beretta at an awkward angle and you don't have a good grip on it, and the slide, and you're racking, the slide comes back and hits something here, preventing it from going all the way back, could that sort of action keep the Beretta from ejecting the casing?
Can you repeat the question one more time? I'm sorry.
Yep. So if you're trying to fire the gun and you're racking the slide back, but there's an object right here that's preventing, the slide hits and doesn't come all the way back. Is that something that could prevent a shell casing from being ejected?
If it's coming back, the casing has already been ejected. So it would affect more along the lines of the next cartridge being inserted into the chamber.
Okay.
If there was something blocking, so let's say you shoot the gun and there's something physically blocking the slide as it moves rearward, that could affect the casing coming out of the chamber. Yes.
Okay. And would that have any effect on a live round being ejected coming out of the gun?
If you shoot the firearm and it does not eject properly, it could cause the next cartridge to be pulled, which would cause a double feed situation. It would just cause another malfunction in the situation. But I would not expect a cartridge to just flop out. It would lock up the gun.
So what are the ways that live rounds can be ejected from a gun like the Beretta?
If you are using the firearm properly, just racking the slide would get the cartridge out, or just dropping the mag and doing it and removing them from the magazine itself.
And if you are not operating the gun properly?
Those are still the only ways that I could see you removing the cartridges, is racking the slide. There may be a malfunction, or removing the magazine and then removing the cartridges from the magazine itself.
Okay, thank you.
Thank you for your testimony. You may be excused.
Yeah.
You're good. Thank you.
Thank you.
What do you have next?
We have one that's ready to,
Short, long?
medium.
Okay.
Not horribly long, not horribly 5 seconds.
Who might it be?
Jake London.
Let's go ahead and get started and then we'll go from there. Thank you. Welcome, come on up. Do you swear affirm the testimony you're about to give be the truth, whole truth, nothing but the true self you God? I do. Thank you so much. You can have a seat, please. Speak in the microphone.
Please introduce yourself to the jury.
Jacob London.
What is your current, are you a lieutenant?
I'm a lieutenant, yes, ma'am.
Okay. Oh, thank you. Where are you currently employed?
With the Hall County Sheriff's Office.
How long have you been employed with the sheriff's office?
Just shy of 18 years.
Okay, so let's start from the beginning. How did you start out?
I started off as a jailer in April of '08. Eventually made my way to a deputy on patrol. Then I did a short stint with DUI task force and then to investigations and then moved up through investigations.
Okay, what is your current role?
I'm a lieutenant over the Forensic Intelligence Center and our crime scene unit. I'm sorry.
How long have you been, I guess, the supervisor in that role?
A year and a half.
What kind of duties are you tasked with, I guess, in digital forensics in that unit?
Now I'm tasked with supervision, but at once upon a time I did all the digital forensics for the sheriff's office.
By you did all the digital forensics, what do you mean?
I process every cell phone or computer that needs to be processed for evidentiary value.
What kind of training and, I guess, experience do you have in doing digital forensics and analytics?
Training, I did a 40-hour course with Cellbrite, and then I've done over 200 hours with the National Computer Forensic Institute in Hoover, Alabama with the Secret Service.
Were you in your current role in March of 2025?
I believe I was a sergeant in March of 2025.
Okay.
In that same role.
Okay, in the same role, like doing the
Cell phones and
the
computers.
cell phones and computers. Okay. How did you get involved in this case?
I received a request from Investigator Medford to process 2 cell phones.
2 cell phones. Okay. So what kind of phones were there?
There was a blue iPhone 13 Pro Max, I believe, and a gray iPhone 11.
Okay. And to your knowledge, who owned the blue iPhone?
I believe it's the defendants. The blue one's the defendants.
Okay. Can you tell the jury what a cell phone extraction is?
It's basically a digital copy of the phone. So we don't actually, we call it an extraction, but we don't actually take anything off the phone. We just basically do a copy of the phone.
What happens when you first get a cell phone to analyze?
When I first get it, I look at it and make sure that's what, it was described as in the search warrant. And then I log it into our system. We have a spreadsheet in my office where each case is assigned a bin and a charging station because they need to be charged to be processed. And then once it's able to be processed, then I take it to my computer and start plugging it in.
So you mentioned a warrant. In this case, did you get a warrant to get him to both of the phones?
Yes, ma'am.
So you mentioned plugging in the phone. So you get a phone, you plug it in. How do you get into the phone?
So I technically do not. There's a software called Cellbrite. We purchased it. We'll open it on my computer. There's also a digital machine that comes with, or a machine that comes with, a forensic machine that comes with this little box. I open that on the computer. I turn the box on, or I click some buttons and I turn the box on, and then I eventually plug the phone into the forensic machine, which is the little box.
So you plug it in, you plug it into this little box. What kind of data are you able to extract if the phone is successfully extracted, ran through the program?
Everything I think the extraction we get most. I can't say how much we get, how much we don't get, because that would take a lot of going through the phone manually and all that fun stuff. But we try to do a full file system, which is the best possible extraction I can do.
Okay, so let me show you. This has already been tendered as State's Exhibit 182. Is this one of the cell phones that you did an extraction on in this case?
This appears to be the blue iPhone in this case. Yes, ma'am.
Okay, the blue iPhone, is that the iPhone 13?
Yes, ma'am.
Okay, and are your initials on this?
They are.
package? They are.
They're on each top corner of the back.
Okay, I can take that back. Were you able to successfully extract data from both of the phones?
Yes, ma'am.
And did you perform a phone extraction or cell dump on the blue iPhone 13?
I did.
Okay, so I'm going to show you what's been pre-marked as States 199. This is just her phone number. No, this is the entire video.
Those are separate.
Those are separate. Those came from the dump. Yes. Okay. So I'm going to show you just what's been pre-marked as states 199.
Yes,
Do
ma'am.
you know what's on this?
It's the report from the phone extraction.
Did you review this hard drive prior to coming to court today?
I did.
And you said that there's a phone extraction on here. Which phone extraction is that for?
The blue Apple iPhone 13.
Okay, and is what is on this hard drive a fair and accurate copy of the phone extraction that you did perform?
Yes, ma'am.
Okay, the state moves to tender State's Exhibit 199 into evidence.
Can we get the date again of the extraction?
The date of the extraction. Actually, yes, I have another exhibit that shows it.
Can the witness just tell us?
I believe it was March the 17th of 2025
Okay.
for the blue iPhone.
No further objection to 199?
Thank you.
Admit, it was 199.
It was 199.
Admitted.
Okay, so it's for the record. I'm going to show you now what's been marked as State's 199A. What is that? What does that say?
So when the extraction is completed, there's another software that we purchased from Cellbrite called Physical Analyzer. That's where I take the extraction, which is technically ones and zeros, like, everybody's seen the computer, it's all ones and zeros. The extractions are like that. And then I take it and put it into Physical Analyzer, which is a parsing software, so we can view it all. And then I generate a report from that. And this is a snippet of the home screen of that report. It shows the device information.
Does that photo or screenshot fairly and accurately reflect what, Cellbrite or the Physical Analyzer looks like when you load up the defendant's cell dump on the computer?
Yes, ma'am. This is
Okay.
the device info section of it. Yes, ma'am.
The state would like to tender State's Exhibit 199A into evidence.
No further objection to 199A.
Admitted.
Permission to publish?
What are you looking to publish?
Well, we have it on, it's the screenshot, Judge.
Okay.
We have it on the computer. Oh, you did? Oh, okay. Okay, so I just want to ask you a few questions about this. Oh. Is that good? Okay. Thank you so much. Okay, so looking at this screenshot, what do you see?
So you see the extraction start time, which would be March 17th, 2025 at 11:28 hours. And then what time, how long it took, basically. So when it ended was March 17th, 2025 at 3 p.m.
And that's in that red box?
It's in the top box there, yes, next to the display of a cell phone.
Is that your name underneath there?
It is.
Okay, so tell me a little bit about, tell me a little, oh my goodness, doing this upside down. Tell me a little bit about this data that you see over here. What is that? What's that reflecting?
So it shows the Apple ID that's attached to the phone. There's actually two here. So like your email that you have to use for Apple to download apps and all that fun stuff. It shows two here. One is drmiracle.miracledentistry@gmail.com. And the other one is susanna.haley123@gmail.com.
Is it fair to say this phone belongs to the defendant?
Yes, ma'am.
Okay, so I want to ask you, oh yes, thank you so much. Okay. So you see some little boxes up here underneath this blue box that says home. It says timeline. What's that?
It's so if you were to click on that, it will open up an entire timeline for the phone. So when she first got the phone, if say it was from the store, it will show from then until the date of extraction. If she bought it from a secondary party and it was factory reset, it would be from that time until the date of the extraction.
Can phone dumps or cell phone extractions be large?
Yes, ma'am.
if you are in the Cellbrite software, like we see in the screenshot, and you said the timeline, you get the entirety of the phone, are you able to filter results or look for certain things?
Yes, ma'am.
What kind of things can you look for?
Dates, times, you can filter between messages, phone calls, contacts, log entries. I mean, basically, there's a lot.
Okay, so if I were to hypothetically look up the word blue, could I filter and make a report of any time the word blue was mentioned in the phone?
The word blue or the spelling BLUE within any other word.
Okay. How do you run a report on Cellbrite?
How do I generate a report?
Yeah, generate a report.
So once it's loaded into Physical Analyzer, the screen looks very similar as what it would here. It's kind of hard to do from here. There's on the top right of the screen, what I don't think you can see on this snippet, there is a button that says Generate Report. So you click that, you have to enter some data like a case number. I tried to do case number. There's a file path where you wanted to save the file to, things of that nature. Then there's different reports you can generate within Cellbrite. You can do HTML, which is like an internet-based, or XML. We always use Cellbrite Reader, which is the UFDR report, which is a Cellbrite Reader report, which is what you see here.
Are you also able to find and filter out pictures on a Cellbrite report, or generate a report with pictures if you wanted to?
Yes, ma'am.
I'm going to show you what's been pre-marked as States Exhibits 199B and 199C. What are these?
So these are basically a snip of a picture that was on the report from the phone.
What does it mean if a snippet says something was created?
That's when it was taken.
Okay. By the user of the phone?
I believe so, yes, ma'am.
I can take those. And your previous answer, was that as to both 199B
I'm
and
sorry.
199C?
I didn't see it.
Yeah, there's two.
Yes, it's just a separate picture or a different picture from the phone.
And did these come from the defendant's cell phone dump?
Yes, ma'am.
I'm going to show you now, and there's going to be quite a few, what's been pre-marked as, what's been pre-marked as States Exhibits 199D through 199S. And I'm going to ask you, because there's quite a number of them, can you just thumb through them and then give me a look when you're done thumbing through them? Actually, you know what? Starting from 199D, can you tell me what it depicts?
So 199D appears to be a timeline from March the 8th of 2025 through at 1:10 a.m. to March the 8th, 2025 at 1:23 a.m. And it appears to be the call log of the cell phone.
Okay. What about 199E?
199E. This was a little more lengthy. It appears to be a call or a timeline with different filters. This one has contacts, a call log, and messages from the defendant's phone to or from, whichever way it would go, with a Beth Barron. And that's from October 28th of 2024 until February the 3rd of 2025.
What about 199F?
199F is a timeline of a call log between the defendant's phone and a Brittany Barron and there's 2 times on that, which is February the 28th of 2024 and February the 16th of 2025.
What about 199G?
So it's again a timeline report of messages and call logs and contacts. And device notifications from the defendant and a Dana Miracle Gardner.
What about 199H?
It's a timeline of messages from January 22nd to February the 12th with a David Barron and the defendant.
What about let me see that one. Is there another participant in the flip flop?
There's a David Barron, Susan, and then a Dana Miracle Gardner as well.
What about, that was H, what about I?
I is a timeline again with call logs, messages. I'm sorry, I have to go through them. Call logs and messages from February the 28th until, December 28th of 2024 through February 16th, 2025 between the defendant and Evan Barron.
199J.
There appears to be a timeline of text or instant messages from February the 2nd at 12:43 till February 2nd at 3:23 between the defendant and a Mike Harris and Judy Dixon.
199K.
This again is a timeline of call logs and messages and device notifications. And emails as well on this one. From January the 20th of 2025 until March the 7th, 2025. And it appears to be with a Jennifer Hall.
199L.
This is a timeline of so far some log entries. This is log entries and text messages, device notifications. There's some notes in here as well. Messages. This runs from October the 10th of 2024. Until March the 8th of 2025. And there's messages between Jessica Sellers and the defendant.
199M.
It's a timeline with has some web history, messages, log entries, call logs, dated October the 15th, 2024 until March 8th of 2024. And this with a Dana Miracle Gardner and the defendant.
All right, everyone. We are going to be heading over, June and I, to the Hawaii versus Dr. Koenig. We will be going live in about 9 minutes. We will be playing Georgia versus Suzanne Miracle, the replay day 2 in their breaks and lunches as a filler. We want to invite you guys over to join us. If you remember earlier in the live, I said we were going to have a early afternoon, evening live tonight. So we wanted to invite you guys over to join us for that. We are still in verdict watch for Judy Church. About 2.5 hours now. I still have that up and going. So if there's a verdict, even when we're streaming the Hawaii versus Dr. Koenig, we will switch over and go with that verdict if we have one. If not, then I'm sure they will come in and tell us, or we will see them again on Monday. So we will just keep an eye on it. We do have the giveaway for the entries. We're going to go ahead and run those. Let me get those shared. June, you want to play us some music? Ba-doop-ba-doop-ba-doop-ba-doop-ba-doop-ba-doop. Ba-doop-ba-doop-ba-doop-ba-doop-ba-doop. Ba-doop-ba-doop. Sarah, congratulations.
Sarah!
You have an entry for the end of the month drawing.
Screenshot that, and that was one sunny day.
Yep. Now there was 5. Do we want to do another one?
Yeah, let's do one more.
Yeah, because we only have one I shared, so that one's automatically going to get that entry.
Angela.
Here we go. Here we go. Here we go. Yeah. There we go. Congratulations. Hello, hello, it's Brett.
Hello, it's Brett.
Yep. All right. We do want to thank you guys for joining us today. We are going to go ahead, like I said, and start the live for Hawaii versus Dr. Koenig. We hope to see you guys over there. And in the famous words of our creator, bye.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.